Move over if you want.
Okay, and we're on.
All right. Good evening. I'd like to welcome everybody to the June 11th meeting of the Town of Berthoud Planning Commission. As always, I'd like to ask it our tradition to start each meeting with a pledge. If you'd stand with me. Pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
Thank you. All right. Ms. Manzo, can you call the roll, please?
Commissioner Semadalis?
Here.
Commissioner Filio?
Present.
Commissioner Hoffmans? Absent. Commissioner Pond? Absent. Commissioner Butis? Here. And Commissioner Taratzis?
Here.
All right. Good evening. I'm Stacy Sigmund, the chair of the Planning Commission. I'd like to thank you all for being with us this evening. Copies of tonight's agenda are on the table in the center of the room. Please feel free to come up and take one if you need to. I'd also like to ask everybody to take a moment and silence their phone, including me. First item on our agenda this evening is the approval of the meeting minutes from May 28th, 2026. Does anybody have any amendments on those draft minutes?
Yes, I had two under number 3 roll call. Commissioner Semadalis and Commissioner Philo were not present at that meeting. And I guess with that, I would make a motion to approve as amended.
Do I have a second?
I second.
Great. All in favor?
Aye.
Aye.
Any opposed? Great. It's been moved and seconded, and after a vote, the meeting minutes of the May 28th Planning Commission have been approved. For our action items this evening, we have no matters scheduled for public hearing, so we're going to move right into our 2 work sessions. Item number 1 is our technical assistance. Brian Fisher, our town's IT specialist, is going to join us for this portion of the meeting.
Maybe.
I cannot find him. I can't find him. He's not in his office. So does anybody that's here, do you need technical assistance? And I will arrange a one-on-one with you. All good?
Everybody good? Well, that's nice.
All right.
Okay. Well, then item number 2, that was a fast initial workshop, is a training session really for all of us, our Plan Commission roles and responsibilities. This evening we have Sam Light, the General Counsel with CIRSA, and Ann Best Johnson, our Community Development Director, to help us with this item. Ms. Johnson, can I ask you to start us off, please?
Sure. Thank you, Chair Sigmund. So tonight we are going to go, some of this information is going to be familiar to you because it's in the orientation packet. We're just really lucky to have CIRSA with us tonight. And so Sam's going to start off, then staff will jump in, and then Sam will do a big bulk of the presentation, and then staff will finish it up. If we don't have time to finish staff's, and if we're getting late and you're tired, staff can come back and finish it up another time. However, everything really does go together nicely, so we'd like it to be nice. This is meant to be conversational. It's not a lecture. It's a way for you to ask questions. Sam will explain what CIRSA is and why they keep us out of trouble. And keep you out of trouble. So Sam will talk about those things first, do an introduction, and then I'll just introduce again the concept of planning. So hopefully you all listened during orientation. So if I ask questions, you'll be able to answer them. So again, Sam Light is the Deputy Executive Director and General Counsel for CIRSA.
And if I could just add one thing, David, our village attorney, was unable to be with us this evening, unfortunately. So he sent a note, and if there's a time when he will be joining us in the future if we have land use cases that may be controversial or staff thinks we may need some support on, kind of regular meetings that are pretty straightforward, he won't be. But certainly I think if we have any questions for him that Sam can't answer, we can bring him back another night, arrange a time at the end of another meeting.
Yep, and there will be things that Sam will want to defer to the attorney instead of,
Yes.
making a general statement. So we will definitely take notes about those things. Thank you.
Great. Thank you, Ann, for that introduction. Thank you, Chair and Commissioners and staff for having me out. It's good to see you all. Thanks for the invitation to come up and visit with you all.
Thanks
Yeah.
for being here.
Yeah,
Thank you.
it's my pleasure. So again, I'm Sam Light, and I'm the Deputy Executive Director and General Counsel for CIRSA, which is an acronym for the Colorado Intergovernmental Risk Sharing Agency, which is kind of a mouthful for why we call it CIRSA. So we're the town's insurance provider for property and casualty and workers' compensation coverage. So our bread and butter, of course, is to issue the insurance coverage and deal with the claims on several different risk exposures. On the property side, we provide the property coverage for your buildings, your vehicles, your equipment, your other hard assets. We provide the liability coverage, everything from auto liability to, somebody has a slip and fall out on a town sidewalk and they think it's your fault, we cover those kinds of claims. All the way to the more esoteric types of coverages and claims that we deal with in the municipal world, things like police liability, bodily injury, or we provide the liability coverage, everything. Perhaps most liability you all do. Somebody has a slip or elected and appointed officials. We provide public officials liability, we cover those kinds of claims. Right, to help protect more you doing your job as planning commissioners on behalf of the town. So you can learn more about CIRSA at www.cirsa.org. Sorry, let me move a couple of things around there. The slides, as I understand it, are, I think, in your packet or are available to you as a resource. I hope they're a helpful tool for you all. But you can learn more at our website. So there's a couple of links on this slide. You can learn more about CIRSA at www.cirsa.org. Sorry, or of interest to you all. Things around there. Give you a little bit more sense of what slides, as I understand it, are not a commercial. I think in your packet or are available to you as a resource. I hope they're a helpful tool. And we ourselves are you all, but you can learn more at our website under Colorado. So there's a couple of links on this slide. You can learn more about CIRSA at www.cirsa.org. Sorry, to you all. Things around there. Give you a little bit more sense of what slides, as I understand it, are not a commercial. I think in your packet or are available to you as a resource. Give you a sense of our size. We ourselves are you all, but you can learn more at our website under Colorado. There's a couple of links on this slide. You can learn more about CIRSA at www.cirsa.org. One of the things we do at CIRSA, being member-owned, around there, a little bit more sense of slides, as I understand, we are not a commercial management packet or are available to you as a resource. Give you a sense of our size. We ourselves are you all, but you can learn more at our website under Colorado. There's a couple of links on this slide. You can learn more about CIRSA at www.cirsa.org. One of the things we do at CIRSA, being member-owned, around there, a little bit more sense of slides, as I understand, we are not a commercial management packet or are available to you as a resource. Give you a sense of our as a whole. So the way it influences risk management is we try to provide resources for all of our members at all levels of the organization that are there for you to use as members as much or as little as you would like to help exercise the muscle around risk management, right? So, for example, for the operations folks and the police, we do all sorts of trainings, and both virtually and in person for them, and we have a library of online resources. But myself, our executive director, and our associate general counsel, we do trainings for elected and appointed officials. So this is an opportunity for us to all flex that muscle around basic concepts of best practices for quasi-judicial decision making, which is the bread and butter of what you do, right, as the Planning Commission. So I understand, do we have some fairly new appointments on the commission? A couple, two, just kind of brand new?
Third meeting?
Third meeting? All right, congratulations. And then we have some veterans. Been around a while? Right.
One veteran.
One veteran. All right. Well, whether you've been around a while or new, I hope you find this useful. As Ann mentioned, please feel free to ask questions as we go through the material. She was spot on, however, when she noted this one point. Actually, there's two disclaimers. Though I am an attorney, of course, my training is not an attorney-client discussion. It's a presentation only. And then second, please feel free to ask questions. I'm happy to give you CIRSA's perspective on questions that you may have with this caveat. If my radar is going off telling me that feels like the live burning question of the day, for which you need legal advice in the here and now as the Planning Commission, then I'll probably defer on that, right? You know how it goes. Sometimes somebody will ask me, Sam, I've got a, hey, great comment about ethics and how they apply to us as a planning commission, but I've got a question. What if another member of the commission does this? And everyone's eyes open wide, you know, I go, okay, that sounds like something going on here and now. So that's going to be for your attorneys. And then same thing if it feels like your question relates to some pending matter you got going on that really is in Ann's wheelhouse for Ann and her team. So that's my two disclaimers. Let's talk a little bit about, I'm going to turn it back to Ann for a couple of introductory slides on the broad concepts of what's our role, what's our job, why are we even in this business as municipalities, and then I'm going to talk a little bit about what I call the grand bargain of land use planning. So,
All right, so thank you. So again, our role as staff, the referral agencies, planning commission, when you act as the board of adjustment, and even to the town trustees, our role is to achieve this desired outcome, the vision for the town of Berthoud and the future growth in a legal manner. That's why Sam and Nick and Catherine and Kendra come. And equitable, so everybody is treated the same, and an ethical manner. So we're not asking for brown paper bags under our passenger side wheel to be waiting for us. It's everything is ethical. We treat everybody the same. So everybody's roles and functions. Developer, their role and their function in this process is they design a product, they need to get it permitted, and then they construct it if they're designing it and permitting it in a way that the town wants to happen, as established in the comp plan, our land use code, or any other development codes. Sorry, I'm wandering without this. Staff, then what staff's role is preparing the plans, the presentations, doing the development review. We serve as an educational resource. Many of you have called us if you have questions. We also are educational resources to, we prepare presentations to the school district or to the historical society or other organizations in town. We are advocates for a clear and certain process. We don't advocate for some application. If you deny an application, if you disagree with staff's interpretation, that's okay, because we are advocating for that process. And then we also advocate for how a project fits into the master plans. How does it fit with that trail master plan? Even though our comprehensive plan is not regulatory, it's a vision document, how does it fit within that implied vision? And then we keep and maintain development records, and we serve as support to you as well as the town trustees. So then legal counsel, they ensure all actions are legal. You all do, Sam, I've got to tell you, they do an amazing job walking through. If it's a controversial case, they'll take every criteria for approval and they'll discuss that. And one thing that you all can start doing is, if it's a non-controversial case, we don't have a lot of people, you could just talk about the criteria for approval in general, and you don't have to go through all of those steps. It's entirely up to you, though. You can set the record how you want to. And then also offer interpretation of the code if there's a question. Their legal counsel and staff are there to offer interpretation of the code. Then your role is hearing these land use requests to provide due process. Staff gives a presentation, the applicant gives their presentation, and then you have members of the audience who may want to give you their opinions. And then we adhere to the criteria. You adhere to the criteria for approval. You're adopting master plans. The last big plan you worked on was the housing plan. And next year, depending on if we get budget, we'll be looking at portions of the comprehensive plan as well. And then amend land use regulations as needed. So, and then the public, their role in all of this is also to provide their testimony. So all of these interests are coming together, and you all are steering that ship to make sure it's equitable, it's ethical, and it's consistent. So again, lots of different opinions, lots of different motivations for getting involved. And what we've found is that providing that strategic leadership and facilitation is one of the top criteria why a developer would come to Berthoud. So as you're deliberating with the criteria for approval, you are showing that you're equitable, you're just, and you're following a process. So that is enticing to a developer when you're going that path. It's clear and it's a published process. Okay, I'm going to turn the next several slides back over to Sam, and then I will stop pacing.
All right. Thank you. I would add, if we go back to this last slide real quick, important roles, fairness of process, predictable process, right? Tough but fair, right? Do you agree that your job sometimes you're going to make decisions that aren't going to make 100% of the people happy 100% of the time, right? But if people walk away from one of those tough land use decisions where you're making a recommendation to the town board, you know, what a great thing in terms of faith and trust in your processes and in you all as commissioners and as the town as an organization. If a person walks away, it's okay if they say, hey, I disagree with what the commission recommended, you know, but what we want them to say, but it was a fair process. I feel like I was heard, I feel like I was respected, and I understand the decision that they made. They may not agree, right? But that's okay, right? That's much better than a process where persons, in our world, in the claims world, it's not true with all of our claims, but sometimes it becomes apparent after the fact that one of the reasons the person pursued litigation is because they went home and said something like, well, not only do I disagree with what they recommended or decided, but I feel like it was a bad process, like I was tuned out, like they were talking about some strange things that I didn't apply to the application, and I'm so mad about it, I'm going to see if I can find a legal way to challenge that decision. So a process is very, very important. Now, we're going to talk a little bit about this role of being a quasi-judicial decision maker, but I just want to start with a couple more high-level concepts. What a great thing in Colorado. Not all states have this, but in Colorado we have local control of land use. What a great thing. And we want it, right? We want it. We don't want the county making decisions for us on subdivisions or rezonings, right? I guess the things over the last couple of years with what's going on in the legislature and the governor's office kind of reminded us of that, because I remember the municipal community was fighting pretty hard to say local control. We want that power to make those decisions, right? But we're now in Berthoud. Have you crossed that line now where you're more than 15,000?
We're really
You're right there.
close. Yeah,
You're
if
right
we
there. You're
haven't
like,
yet, we're-
yeah, you're like one moving truck away from being a community of 15,000 people, right? And at the end of the day, we got 7 members on the town board and 7 members on the planning commission, right? Of those 15,000 people, only 14 people ultimately are vested with the authority, right, to decide whether someone can subdivide their property or rezone or get approval of a special use permit or a development plan or a variance. So that's an awesome power, right? But the grand bargain from a legal perspective is if we want that power, we need to make sure that we are honoring people's due process rights, right? And the framework within which we do this is, you all know this already, but when you make those decisions on specific land use applications, you're acting as judges, right? And that's why we call that role being a quasi-judicial decision maker. Who likes that phrase? Quasi. I've been doing this for many, many years, and sometimes I think that I hate that phrase more every day because it just sounds confused. What is quasi-judicial? It just means judge-like. I would encourage you to say, hey, we're judges. We're judges. Yeah, we don't wear a robe and it's informal, but ours is when we have applications in front of us, it's an adjudicatory process. We're basically sitting as a panel of judges, right? This concept of being quasi-judicial decision maker, it's a little bit counterintuitive. It's a little bit lesser known aspect of municipal government, right? But it's critically important because that's the area where you and the town board are making decisions that affect individual persons' protected property rights. And so we can imagine, right, the stakes are pretty high, right? hey, that's my property. I have a right to do something with it. You're taking away my right, you know? So the stakes around these processes can be quite significant, and missteps as quasi-judicial decision makers, right, can have pretty significant legal consequences. Among the types of claims that we handle at CIRSA is we do handle some land use challenges every now and then. I'm going to talk about what that risk exposure looks like in a little bit. Okay, so to build a little bit more on Ann's slide about the things that you do, from an attorney's perspective, your responsibilities on the Planning Commission can be broken into two broad categories. One is the big picture stuff, right? And Ann mentioned some of that already. You help make or amend the comprehensive plan. I was looking at your website. You got a nice list of great comprehensive plans. You got open space, trails, right? And they got housing in the mix and others. Yeah, so you're doing that hard work to help this community plan for where do we want to be in 5, 10, 15, 20 years, right? What a great thing. That's the visionary work, right? Where there's no specific applicant in front of you and you're not making a decision that affects a specific individual. So that's kind of legislative work, right? And then the other half of the job, or more, I don't know how your agendas balance out, but the other part of that is the decisions that you make that affect individual property rights who come before you and request your recommendation or decision affecting their property. And when you're making decisions concerning those individual rights, you're acting as judges. That's the quasi-judicial piece. We presented on this a long time at CIRSA, and one thing we finally figured out is that in terms of thinking through what this really means, a good way to look at quasi-judicial decision-making as we start to dig into it is first to compare it to legislative decision-making, right? And so let's look at the top of the pecking order legislative body within our community, and that's the town board, right? So if you kind of look at the types of things that the town board does that's legislative, you can see the contrast that I'm going to set up between legislative decision making and the way we conduct ourselves around legislative decision making as contrasted with quasi-judicial rules of engagement, right? So when you look at the things the board does at a legislative level, you can see how it's broad policy stuff. Here's some examples on this slide, like the question of maybe in the land use area, should we have an ordinance at all to regulate food trucks? Do you have such an ordinance? I'm just curious. For some of our members, it's a hot topic, and they get into the zoning code and they talk about where food trucks are allowed or not allowed. What about, should we have an ordinance? It's kind of a hot topic today. Should we get into the land use code and have an ordinance that regulates data centers? I don't know. Are you there yet? If you read the headlines this week, there's several municipalities that are right in the mix on this issue, right? But the question of whether to have those kind of regulations at all, from a policy perspective, that's a legislative matter, right? And when the town board is thinking about legislation in the land use arena, they can engage in, and when you're making recommendations on these broad policy questions, you can engage in the kind of conduct that legislators engage in. For example, you can vote your recommendation or vote on the town board can vote on the ordinance based on their own personal policy preferences. Hey, I don't want any food trucks in town. I'm going to vote no. I'm going to vote yes, whatever it may be. You can do your own research. As long as you're following the open meetings law, you can also work to build consensus around the policy issue. You can also talk to citizens who want to lobby you or that kind of thing about the issue outside of the meeting, right? And when ultimately the matter's in front of the town board or for you for a recommendation on some, let's say, a code amendment that's been referred to you for feedback, on those policy making issues, you ultimately can vote, your own convictions, your own opinions, your own prejudices on what you'd like to see from a policy standpoint. That all sounds like legislative activity. And we think, hey, think like state legislature in that regard, right? For you all, going back to Ann's slide, your role of making recommendations on amendments to the comprehensive plan is probably the part of your work that's most analogous to the legislative work of the town board. That's when you're visioning, thinking about big picture stuff, and you aren't making a recommendation or decision that affects the specific rights of any individual. Okay. In contrast, quasi-judicial decision making, right, is the area where you're making decisions that affect individuals' property rights. Just borrowing from your development code, and you got a new development code, right? Yeah. It's a maybe less than a year old adopted land. Congratulations. Was that a little bit of work?
Just a little for
Just a
staff.
little, yeah.
Just
Well, and for you all too, right? Yeah, that's a big lift for an organization. Before I joined Sursa, I was a municipal attorney for many, many years, and once in a while I get some special counsel work or new client work, and we go, okay, it's coming, Let's take a look at the land use code and see how it looks. And you'd look at it, and the land use code would be on some faded yellow paper, and it was written in about 1978. And I said, are we ready for the future with this land use code? Probably not. But as a community, it's a huge lift to set aside the time and the resources to update your development code. So kudos to you for doing that hard work. To give you examples of quasi-judicial decision-making activities that flow directly from your development code, right? It would be decisions like applications for a request to subdivide a parcel, for rezoning, for approval of a PUD plan or an amendment to a PUD plan, request for approval by use by special review, and you sit as the Board of Adjustment as well, right?
Yep.
Although my presentation isn't focused on variance criteria, that's tricky business, right? But when you sit in that role too, individual variance requests are quasi-judicial as well. Those are all, and in that context, we're thinking and acting like judges, right? When it comes to quasi-judicial matters, if you go back to the prior slide, those activities that are listed there in red, the legislative activities, right? They're problematic because for quasi-judicial decision-making, you are not legislators, you're judges, right? So just to make sure we're all kind of level set on what a good working definition of quasi-judicial is, it's basically a proceeding, right, where there's a decision that is made on the basis of specific criteria, right? And there's a hearing, right, in front of you where everyone gets to provide their evidence and testimony. And then you have to make your decision based on the application of the pre-existing criteria. That's so important, pre-existing criteria. You got to pick up that staff report and work through those criteria. You're applying those specific criteria to the information that you learned at the hearing, and the decision has to be made by a fair and impartial decision maker. That's all of you, right? So that's quasi-judicial decision making in a nutshell. 4 elements. It affects the individual, decision based on specific criteria, facts developed at a hearing, and a decision reached by a fair and impartial decision maker. Let me ask this question, particularly for the new folks. Do you like process?
Depends.
We love process, right? Yeah, we get a bad rap. We get a bad rap in local government every now and then. You know, people, maybe somebody's going to tell you this once in a while. Hey, why does the process take so long? Why are there so many steps in the process? We have to remember, right, as champions of our community and local government, that our processes are intentional, right? And they're there for many reasons, but among the reasons from an attorney's perspective is to ensure we make fair, predictable decisions, that people who come before us with like applications are treated in the same manner, right? And that the people know the rules of the game. You can imagine from the applicant standpoint, if the rules are unclear to them, are they going to make the investment? Yeah, probably not, right? Now they're running a risk. They know that if they know what the rules are in advance, but they want to submit something that doesn't comply with the rules, then they know that might be a stranded investment on their part. But they appreciate knowing what the rules are in advance, right? So, and then we want to make sure that we're being champions of the processes in place. So if you ever have that citizen putting a bug in your ear about the frustration with the process, a couple of things. Number one, first refer them to your planning staff, because that was never part of your role. You don't have to, they can kind of unburden you of that and help explain what the processes are, but also have your radar up and make sure that we're not being conscripted into an attempt by someone who wants to make an end run around process, and they're trying to enlist your help in that, right? Okay, well, here's an interesting thing from an attorney standpoint about quasi-judicial stuff. Process is so important from a legal exposure standpoint, because if your process is correct, right, then that's a wonderful thing. If your process is right, just imagine this, like the most common challenge under state law to a land use decision is what's called a Rule 106 challenge, right? And that's basically where someone who's wants to challenge your decision goes to state district court and files a challenge and says, court, I'd like you to rule that the decision of the town that was arrived at through the planning commission and town board process was either arbitrary and capricious or beyond the jurisdiction of the decision makers, right? In that regard, the judge, the role of the judge is not to revisit the substance of your decision. Can you imagine that? Right? And the district court judge says, I got a challenge here to this application that was approved in Berthoud. It was for an apartment building that's 5 stories tall. And the district court looks at it and goes, well, I know a little bit about Berthoud. I just think that's too tall for them. I'm going to overturn. That's not their job. Their job is to make sure that you apply your rules consistently and even-handedly, right? So as long as your process is carried out fairly and you're applying the rules, right, through a fair and defensible process, then from a state law challenge standpoint, in all likelihood, your decision is going to be upheld. And that's a great thing. And there's less risk in that, right? There's less risk in that because if we win a state court challenge, it's unlikely the person's, even if they're aggressive and try to make a federal claim out of it, it's very unlikely they're going to prevail on their federal claim, right? So, all right, these concepts of rule of engagement, they do sound a little bit counterintuitive. And you go, where does all this come from, right? But we know where it comes from when we step back and say, right, it's a constitutional principle, right, that no person shall be deprived of life, liberty, or property without due process of law. So the grand bargain is that if we want that power, our commitment to them is to honor all interested parties' rights to due process in arriving at a decision. Okay? So we're going to dig into what some of those rules of engagement are, but just as a reminder, when your town attorney and your staff and CIRSA, when we emphasize the need for you to follow these rules of engagement, both individually and collectively, before, during, and after any public hearing, it's to protect your ability to remain one of those decision makers, right? And to help reduce risk for the town. Because we don't want you to ever face a situation where somebody stands up at the beginning of the hearing and says, Madam Chair, I'd like to have a little discussion about an objection I have before you start the hearing. I'd like one of the commissioners to be disqualified because I think they've made some errors and missteps with respect to my due process rights under these rules of engagement. And then you're off to the races with a little mini discussion about whether there's some reason, right, that you have to be bumped off of the hearing panel, right? And then also the rules of engagement are obviously to protect you and your ultimate decision, right? So, but if we follow the rules, it's very difficult for somebody to try and make a federal civil rights case out of a routine land use decision, right? Now, we at CIRSA, we do sometimes get those, but those are the more difficult ones, right? And it's, things like religious uses are tough because there's some federal law around additional rights. Those can end up being federal claims. But if we're treating everybody equally, it's hard to make a federal equal protection claim, right, out of a routine land use case. And it's very difficult to make a procedural due process claim under federal law if we're following our process, right? So that's a great place to be. The reason plaintiffs' attorneys claim it's like federal law claims is because the remedies are much broader. If we do not prevail on the state law challenge, the basic remedy is the court will reverse your decision and send it back to you, okay, for a do-over, which sounds kind of good, but in terms of faith and trust in government, never a good thing, right? To get something sent back to you for a do-over, right? But under federal law, if the plaintiff prevails on a federal civil rights claim, they can get monetary damages. They might be able to get their attorney's fees, so you can see the dollar stakes are much, much higher in that regard. Okay. To sum all that up, from a risk exposure standpoint, if the hearing's carried out properly and the decision's been issued based on the facts that are in the record and we've applied the proper criteria, then in all likelihood, the decision's going to be upheld against the 106 challenge and other recourse such as a federal claim. Probably won't go anywhere, okay? And so all that means that procedure by which you arrived at your decision can be as important, if not more important, from a liability standpoint than the actual substance of your decision.
Sam?
Yes.
Can I ask a procedural question?
Oh, absolutely.
So the Planning Commission is really good about this.
Yeah.
However, could a flaw be that you don't officially open and close, especially closing, that public testimony period? Or is that more of just a procedural?
It would have to be an extreme case because it becomes self-evident by the opening and adjournment of the meeting that you got a beginning and end, right? I think where problems can bubble up, though, is if we end up treating people who want to testify inequitably by kind of opening and closing. And do you have a 3-minute rule?
Yeah.
Or something like that? You can imagine some problems that could bubble up, and it'd have to be a fairly extreme case to end up as a full-blown legal case. But it's more about perception and faith and trust. If you have 3 minutes, what if Citizen Sam stands up, testifies, and at the end, I say, and commissioners, I want to hear your thoughts on this. And then okay, well, I'll indulge that. And now we have a back and forth with Sam for 10 or 15 minutes, but then the next citizen stands up and gets his 3 minutes and asks questions. Then we say, no, your 3 minutes are up. You can hear that citizen says, hey, wait a second, you just had 15 minutes of conversation with Sam, answering his questions and responding to his request for your feedback. How come I don't get that? Or what about the scenario if we close the public hearing? Do you ever knock on? You ever have that when you're deliberating? You've closed the hearing and you brought it back to the commissioners and you're deliberating, but no one else has the first name Sam. Good, okay. So Citizen Sam is the bad actor here. You're in the middle of deliberations and Citizen Sam is in the back of the room waving his arms. I want to say something about that. And Madam Chair says, I'm sorry, the public testimony portion of the hearing's been closed. Right, but you can imagine there could be some problems bubbling up if we open, quote, either implicitly or expressly, we reopen the hearing only for Sam. Sam offers up some blockbuster information that is material to the decision, but we don't allow anybody else to speak to it. Sam waves his arms, he gets a little bit of time with you, and then the developer says, "Can I respond?" No, you can't do that. That would be a problem. Yeah. So, okay. And I'm sure you have a script and a process. And we'll talk about what that means in a little bit. But I like having it sounds like a boring part of the job, but being predictable and following the same steps every time. And even, regulating your own participation around those steps is a good thing, right? So we all get habituated to good, healthy habits around how the hearing goes. And we're going to talk more about that in a minute. Okay, one last thing about quasi-judicial review from the bench. It's absolutely true, right, that you're more out in the community. Planning commissioners don't wear a robe. I think citizens expect that you be approachable. We're going to talk more about that in a moment. But in terms of legal review, the state court judges know that they're not there to second guess the substance of a decision, as long as it's, was based on your criteria. But they're judges too. And so they're going to look at the individual personal conduct of the quasi-judges much in the same way they'd scrutinize the conduct of other judges, right? So we want to always remember that the job with quasi-judicial applications is to think and act like a judge, right? And do the things that judges would do and stay away from the things that judges wouldn't do, right? So we're going to break down what those are here. And feel free to jump in if you have questions. By the way, this slide, along with some other information, is on the handout that we provide. I brought 2 handouts with me. One of them kind of breaks down some of these. So some of the things, these are rules of engagement to apply to all of us individually, as well as all of us collectively, and apply at any time, well before the hearing, right? And all the way through the hearing until after the hearing, okay? So the first is, don't make up your mind before the hearing and don't make prejudicial pre-hearing statements, right? Come to the hearing with an open mind, right? I'm going to pepper this with some fun real-life examples that I've had. Prejudicial pre-hearing statements, right? We got to set aside our own views. We've got to bring an open mind. I'll give you an example that sort of caused some problems, at least in Faith and Trust. This was an elected governing body, not your town board, but you got a beautiful downtown. And you got an overlay zone district for it, I think. Some uses are conditional uses. Yeah, I had a client that had the same kind of thing. Usually in downtowns, we like retail sales tax generating uses. That's kind of a nice thing to have. But I had this client where banks were also allowed, but as a special review use, right? So one of the elected officials, after we had processed about 4 or 5 special review use permits for banks, kind of gratuitously offered during one council meeting. He said, I see we got a special review is coming up for a bank next meeting. And I just want to let you know, I think we got too many banks in this town, and I will never vote for another bank again. Does that sound like a fair and impartial judge? Not a good idea, right? So we got to hold our powder in that regard. Make sure that we don't speak with one side or the other outside of the hearing, before the hearing. That's called ex parte, or outside the hearing communication. We're going to talk more about that in a minute. Obviously, if you have a conflict of interest, personal or financial interest, that requires your recusal, make sure you're fully transparent about that and that you recuse yourself at the appropriate time. We can talk more about that. Are you one of those communities that once in a while people show up with petitions? Well, two things in that regard. As the judges, you obviously don't put your name on those. That's a little weird as a decision maker to see your own name on a petition advocating for or against an application, right? And then second, petitions probably don't play into your criteria. Is that right? Okay, we could talk more about that later in a moment, because that really goes to the question of what credibility and weight do we give to a petition, right? But for purposes of where we're at right now, just remember that petitions, quasi-judicial land use decision making, is not a popularity contest, right? So even if the room is completely packed with everyone saying vote yes or vote no, right? Let's say they're all saying vote no, vote no. If all the evidence points to approval, then what's the decision? Approval. Yeah. It's not about how many signatures we can have on a petition or how much we can pack the room. It's what is the criteria, and where does the evidence lead us with respect to the criteria. Okay? This is a little more nuanced one. Make sure you don't bring to the hearing facts that you know to be true, but which are not part of the record. And that counsels against a couple of things. The staff puts together your staff report, right? And then that's probably got the applicant's material in there, and it's got the referral comments from other agencies. It's probably, once in a while, you probably got a lot of emails from citizens. All that stuff is the record. That's the information for you as the decision makers, right? You should not be doing your own research, fact research, as the judges outside of the hearing, right? You want to remember that we're the judges. So you want to be above all that, and just your only role in the proceeding is to be a judge. You're not a witness. You're not a prosecutor of the case. You're not an advocate for one side or the other, or the investigator. You are the judge. All of those four other roles on this last bullet on this slide, those are for other people, right, who are coming before you. Now, that can be a little frustrating sometimes, because what if you're sitting in a hearing and I'll give you a real life example around one of these. I had a very contested conditional use matter, special review use matter, and the whole issue was about traffic. Is that sometimes an issue for you all? Yeah, right. And so this was a community that had a land use code that required a traffic study. Okay, and the staff during their portion of the presentation talked about the traffic study. The developer had their traffic expert stand up and testify. So staff and the developer concurred that according to the methodology and the criteria used for the traffic standard for the development proposal, it met that standard, right? So one of the quasi-judges started asking some questions and then started saying things like, well, I know what that intersection's like, right? And this was one where we had a couple, and he didn't like the staff's comments because he thought there were problems with the way they were interpreting the traffic study, and he didn't like what the developer was saying. His real issue was, I don't see that there's any traffic counts during peak hours. That's my problem, right? So they continued the hearing, and at the next session of the hearing, the elected official came back and said, as I said last session of our public hearing, I have problems with the traffic study. So since our last meeting, I went and did some of my own traffic counts. Good idea? Right? You can see where this goes from a due process standpoint, right? So he said this thing about, hey, according to my traffic counts, and where does it go? Well, I'm going to make a motion to deny this application because it doesn't meet our traffic standards based on the wonderful testimony of me. Does that sound a little jacked up from a due process standpoint? It is, right? So, but sometimes I'm sympathetic to where you sit, because sometimes you'll have questions, and you might have an idea in your mind about something that you think is factual, but it's not in the record yet. The idea, however, is you don't want to be doing your own research on the computer during the hearing. You don't want to be testifying as a witness, but you have every right to ask people questions, right? So in my example, what that elected official should have done was ask more questions of the applicant and staff. And the easy answer to that problem is he could have said, look, I see from the staff report and the testimony that that's what the traffic study says, but I'm wondering, as a factual matter, do our criteria require that there be traffic counts during peak hours? Oh, yes, it does. Okay. So can staff, even if it's necessary to have a continuance, can we continue the public hearing, right, so that we can get more factual information? Can you bring us more factual information about what the traffic counts are during peak hours? Now, of course, everyone's got to agree to continue and that kind of thing. So that's how you always have the right to ask factual information. We're going to talk a little bit later about when to do that. You don't want to do it early in the hearing. You want to let the record develop, that kind of thing. But that's how you deal with that particular issue. All right, any questions on those? I'll pause for a moment. All right. Another thing to remember as quasi-judge is you want to consider these matters only at your duly noticed public hearing. That is, wait till the matter is ripe, right? You don't want to get involved in all that pre-hearing buzz. You have some controversial applications every once in a while. Yeah, and sometimes the natural inclination, I don't fault them for it. Sometimes the natural inclination of the citizen or other interested party is, well, it's going to be a controversial case. I need to reach out to my planning commissioners to make sure they understand my side, right? No, you got to hold your powder and stay neutral. I call that the lonely part of the job. We're going to talk about that more when we get to ex parte communications. Now, on the other end of the spectrum, so that was kind of the pre-hearing. Stay away from the pre-hearing buzz and don't jump in then. And then at the other end, once the commission has made its decision or recommendation, recognize, hey, that was our group decision. Yes, we're 7 commissioners, and we each add our voice to the deliberations, but the commission speaks with what? One voice. Sometimes it's a 4-3 vote. Sometimes it's a 7-0 vote. That's fine, right? But we have to understand that once the commission has spoken and we've passed that recommendation on, that was the decision of the commission. Okay? It can have a risk dynamic to it. Not letting go can have a risk dynamic. Do you ever, Madam Chair, do you ever have split votes now and then?
We did at the last meeting.
Oh, you did? All right. So if you have a 4-3 vote on some matter, is it okay to go back to your people and tell them, I didn't vote for that stinker? Well, I'm just an insurance guy. If you really want to tell your people, fine. But, maybe the message is a little bit different, right? If you just say, hey, look, I didn't vote for that one, but as the record reflects, and if you were at the meeting or if you watched the meeting, you'll see we had a good deliberation around that. We had various views as a commission about that application, and you can see all that in the record. And I advocated for my view of how the criteria ought to be applied, but ultimately the commission decided to go a different direction, and I respect the decision that was reached by the commission. We've had real liability claims where a person on the 3 side of a 4-3 or 2 on the losing side of a split vote could not let it go and tried to frustrate the effectuation of the decision. Okay, I'll give you a real live example of that. Do you have conditions of approval? Sometimes. I had a split vote. It was a 4-3, and it was a conditional approval. The condition was, they got over the hump and said, we'll approve this upon the condition that you go to the landowner and get a secondary, an easement for a secondary access. That's pretty common kind of thing. You need fire access, right? So they voted 4-3 with that condition, and somebody on the 3 side didn't like the approval. At the hearing, the neighbor was even there and said, well, okay, I get it. I'll negotiate in good faith with the developer for the secondary access easement. I can do that. The person on the 3 side did what after the hearing? Went to the neighbor, right, and tried to convince the neighbor not to grant the easement, right? And we even heard a person say, well, that's my right to do that. But wait a second. That person was just the night before, someone wearing the hat as a member of the governmental body that just gave the approval, was on the body that just created that potential, right, financial and development interest. Now working to undermine the decision that they were a part of the board that made, right? So, and we did, the legal claim that we got, the notice of claim was, hey, this person is tortiously interfering with my prospective business advantage. You all created a right conditionally as a group. You decided that I could pursue this as long as I did that, and now I got one of your own interfering. And they made a tort claim for that. So it is a very interesting legal question that we had to wrestle with, because you can't interfere with your own contracts, but can one individual tortiously interfere with the anticipated business advantage that's created by decisions that you make? So sorry to go down the rabbit hole, but that's just an example of just a reminder to respect the decision that was reached. The other example I have is sometimes I had a 4-3 vote where to flip it around, the people on the for side who voted to approve the development, they were under so much pressure from the community that was, I guess the community was kind of, at least the vocal side of the community was against the application, that the people on the for side felt like they needed to write a letter to the editor explaining why they voted yes. Good idea? Well, it sounds okay, but the problem was the letter to the editor included reasons why they voted yes that weren't part of the record, leading the developer, right, or the opponents to say, well, I guess they voted for reasons that they never made part of the record. I guess the whole thing was arbitrary, right? So we don't want to be doing that either. So we just have to learn to respect the decision, and that's that. And take comfort in the fact that I was one of 7 people that had standing, an opportunity to have a voice in that decision. So, okay, let's see. Let's talk about some hearing issues, and feel free to dive into questions. I'd love to hear how your hearings are going and particular issues you may have going on. But the way you conduct your hearing and the way you conduct yourselves in the hearing, I think greatly impacts not only your risk exposure, but just that core faith and trust about how we as a town handle property rights. So a couple of things, just in advance of the hearing, make sure you come prepared, read your packet. It's okay to jot down your notes in the margin, right, and get your list of questions prepared, your list of key issues for which you might ask questions, right, at the appropriate time in the hearing. Use a script, as we talked about. A couple of things for the chair. You probably heard this from your attorneys, but for purposes of making a record, the record that we make here locally at the town is the one and only record that will ever be used to defend the decision that was reached, right? So we just need to be careful and make sure that everything's identified properly. So the chair is going to work to make sure that we don't have people speaking over each other, that when someone stands up and they forget to give their name, then we're going to make sure they give us their name, that if people show up with documents, commissioners, that everybody gets a copy, and if somebody, the developer or staff says, hey, we need a little time to look at that, see what this is, that we take that time. Whatever it looks like to you, and little tips and tools that the chair has, to make sure we're using proper decorum, and we're, of course, if we want civility and decorum, we want to make sure we're embracing it ourselves, right? Make sure that people recognize the chair's role. We can sometimes we kind of pride ourselves in informality, but we don't want to be informal to a fault, right? Make sure that people speak from the podium, get recognized, that kind of thing. Just out of curiosity, have you ever had one of these land use hearings where people are trying to disrupt the hearing with signs or arm waving or that kind of thing? Couple of them.
Yeah.
Okay. All right. Work with your attorneys and staff to figure out the right tools around those kinds of things.
A lot
There
of
are-
like snickering, whispering really loudly. You
Yeah.
can't understand what they're saying. However, they are talking. A lot of, shaking heads and making disgruntled noises. Those types of things. Somebody had to be escorted out once by the law enforcement.
Yeah.
So some of that type of behavior, but no signs yet.
Okay.
Well, we had the pre-bowl mouse.
Oh yeah. Yeah, we did have mouse signs.
We had the mice and
A mice?
something else. Yeah, I forgot what they.
Oh, okay.
Some other
It's a
signs.
endangered
Okay.
species.
Yeah, I think, there are constitutional issues that come into play. I think it's always the chair's prerogative to make a comment to try and recalibrate people. And I'm sure you have great tactics around that. Hey, folks, let's all be respectful and civil. Let's respect each other's time. Let's give each other full attention. You know, we want to hear from everyone. We respect everyone. We ask that everyone do the same. You know, and that'll rub off on, I don't know what your percentage is, but I would hope 99.9% of the folks. Yeah.
Absolutely.
Okay. Make sure we confine our discussions to the public hearing. As an example, sometimes, well, I don't think you have this. You don't have a general public comment period, and I would recommend against that, right? But you have sometimes you got agenda item A, and somebody stands up during agenda item A, but they're really wanting to speak to agenda item B. Yeah, remind them, wait, you got to wait for agenda item B, right? That kind of thing. And then for internally as well, make sure that we don't, like at the end of the meeting after a land use hearing, during the final commissioner reports before we adjourn, that we don't start talking again about an adjudicatory matter that we had, right? And definitely don't do it during a break. We take a break during a land use hearing. That's a very bad look, right? If we start convening together, first of all, we might have an open meetings problem. But second, even two of you immediately standing up, particularly during a controversial one, standing up and starting to talk to each other, you know, people look at that, what are they talking about? They're supposed to be talking about, you know, even if it's not true, the perception is you might be talking about that case during the break, and that's a problem. So,
Yeah, and kind of on this, and it came up at the last meeting. So one of the things I'm going to try to do in the future meetings to be a little more clear about is, you know, staff will have their presentation and we can ask them questions or clarifications. Petitioner, the same thing. But I want to make sure that we're holding any sort of deliberatory comments, questions, initial thing until the close of the public hearing and it's all back to us, right? And at that point in time, because I think there was some early comments about, I really have trouble with this, or I'm concerned about this. It wasn't overly egregious because we didn't have anybody to talk to it from the public, but I think we need to be careful because on the times that we do, that we're not seeming like we're making any initial thoughts or ideas or opinions before we've heard and closed the public comment period, right? So I
Right.
think sometimes we start to kind of get into deliberations right after the staff and petitioner talks and don't necessarily wait for that opening and closing of the public comment period. Does that make sense?
yeah, and let things ferment. And I think questions or discussions early can sometimes be perceived as leading, right? Let the record develop, right? Because as the record develops, some questions that you might be burning to ask at the beginning will ultimately get answered as people provide their evidence and testimony. Hey, one other comment that I think the screens are frozen.
Oh, okay.
But I'm going to,
Can I ask a question as
Yes.
well? So in terms of asking the questions and things, so once we get that packet, we have a few days to kind of review it, take a look at it. Are you suggesting that we should not be contacting staff and asking questions ahead of time? That we should be waiting and asking only during that public period? Or are we allowed to ask for additional information prior to the hearing?
I've got some thoughts, but if you want to start, I can build on that, or I can start and you can build on it.
Yeah, my answer to that was going to be, it depends.
The lawyerly answer from the planning
It
staff.
depends on the question. And I'm going to let you go ahead and,
I think a mere question about materials or process is fine. I think having a debate with staff about the merits or substance of their staff report would be improper, because they're an interested party as well, right? And asking them for additional information, remember, the whole idea of the due process hearing is everybody gets to hear everybody's information in the same forum so that they can respond to it if they want to, right? They may not want to, but the information has to be transparent for everyone. So, for example, building on traffic studies, it's my favorite topic. If you read the packet and you didn't see the traffic study, you can call staff and say, hey, isn't this an application that requires a traffic study? Will we be receiving that, right? And if the answer is, oh, yes, that's right, we'll be pushing out a supplemental packet for everyone, so you'll get that, right? I think it's also fine to ask your staff a process question if you're getting oriented to the job. But this is more of like things we cover in this training. But if it's your first conditional use and you say, hey, I see in the staff report that the criteria there include some criteria. Can you just, do you, staff, or do you, can you get together with the attorneys and give me some more background as the judge on what that standard means, right? That might be okay, right? But you don't want to work with staff to develop more information about the record, right? Is that helpful?
Yes.
Yeah. Okay. And I have a scenario that talks about one of the other types of risk that arises with regard to contacting staff before the meeting. Okay. I'm just going to go over here to make sure I get the right slide. I'm not sure my clicker's working. A couple of things about the hearing. You ever have that dynamic where you call up someone and you say, Citizen Sam, you're up, and Citizen Sam comes up and says, thank you for the time, and they immediately start talking to the applicant or the staff, right? Remind them to direct their comments and testimony to the judges, right? That kind of thing. Use opportunities, mostly the chair that will do this, but use opportunities to recalibrate if we're straying off topic. Do you ever have that sense once in a while that a land use hearing can sometimes be like ships passing, right? Like maybe you're at the application you have in front of you is the final development plan for an apartment building, right? And so that's the scope of the hearing, but somebody stands up and says, this property should have never been zoned for apartments. Well, that ship has sailed, right? And that's where staff can help. I don't know what you do locally, but those preliminary comments about what the hearing is about is helpful to everyone. And I would encourage it for, public facing. This is a final development plan. And if you in real time see that, you can remind folks, hey, this is the final development plan as is in the staff report. And as staff talked about earlier, our criteria for that are these things. We're talking just about the final development plan issues. And citizens, please give us testimony on those issues. Give us factual information that speaks to the criteria and the application that we're considering tonight, because we want you to give us relevant information. Right? It can be very frustrating if all the testimony you're getting is just on irrelevant things, right? But that's kind of that ship's passing.
Sam, if I could, I want to compliment Planning Commission. A few times Planning Commission has used that Socratic questioning.
Yeah.
They know the answer, however, they'll ask staff, hey, we're at this neighborhood master plan.
All right.
Help me understand where we are in the process.
Right.
What comes next and what is this about? So just what you said, they've done that, which is excellent, because especially during deliberation and you've heard some public testimony that they're confused about what the nature of the hearing is, you can use that as a tool to then get confirmation to put it on the record.
Yeah. Yeah, and both staff and you all can make comments that help remind citizens that there are steps, right? Sometimes it's frustrating for a citizen if you've got all you have in front of you is a subdivision to create a lot for a commercial use. But that's all you're doing is creating the lot. But what do they want to talk about? What's the building going to look like? What kind of architecture? Right? So we remind them, we're not doing hide the ball. Actually, we have more process for you, right? And there will be future land use hearings at which everyone will get notice and we'll take more public testimony. So please come to that as well. But here please give us information that's relevant to the question of the subdivision of the parcel. And isn't that great, citizen? You get an opportunity for public testimony at each and every step in the land use process where there's a quasi-judicial determination to be made, right? The other dynamic we see sometimes, I'm going to try and move this forward again. Seems to be moving on its own every once in a while. You ever have this dynamic where the hearing is overtaken by issues beyond our scope or control? Like the whole issue is people want to talk about the capacity of the school district, and you've gotten a referral letter from the school district that says, we have the capacity to serve, no problem, but what does everybody want to do? They want to adjudicate with you whether there's school district capacity. We have to recalibrate and say, I assume it's not one of your criteria. Right? That's not our issue. That's not our issue. We're here to talk about the land use criteria. What about the quasi-judicial hearing turned legislative debate, either internally or externally? Maybe it's a special review use and the The height limit allows us to go up to 45 feet, but we decide we're all going to talk internally about whether 45 feet was a good idea to begin with. Right? that's the criteria for tonight. At some later date, if the town board takes an interest in that, they might refer to you a code amendment, right, to talk about that issue. But that's a legislative debate. And then we have to also be careful about this. Sometimes we go down the rabbit hole of not talking about the application that we have, but the application that we'd like to see. Right? We have to remember that at the end of the day, the applicant brought you an application. Right? It may not be what we want, but they're entitled to a decision or recommendation on their application. And sometimes it can get so messy that we're kind of left with this question of what are we deciding here? We got to back up here. What we have is this, right? Sometimes we go down the rabbit hole and we think through our discussions that the developer is going to do this, that, and the other thing, but no, this is their plan. This is what they gave us. We can't make something that it isn't, right? So we have to be careful about that as well. All right, I think we talked about witnesses and back and forth with folks during the hearing.
So what you're saying is that planning commission hearing, and this planning commission has not done this.
Yeah.
It's not a time to negotiate terms. We could give you approval if you would just do this.
Right.
It's not a negotiation, it's a decision based on what's being presented.
Right. Yeah. It ties to conditions a little bit too. Sometimes you may feel like you're negotiating conditions. All right, but you want to look to there's a slide on this later, but when you're dealing with conditions, look to your staff and your attorney. Right, the conditions have to be based in your authority, right? And we also have to remember that just if the developer just nods their head, that doesn't make it binding. Everybody can have conditioner's remorse. We can have conditioner's remorse if we're writing a condition at 11:30 at night that's vague and ambiguous, right? And the developer can wake up the next morning and say, well, I got through planning commission with that condition, but I'm going to submit, I'm going to ask the town board to get rid of that condition, right? That kind of thing. Yeah. So we want to make sure we're just focusing on, do they meet our standards and criteria, and our recommendation is centered, right, rock solid on that question. Yeah. Okay.
Yeah, I got one on
Yes, sir.
public comment.
Yeah.
So say that somebody does come up and they're just like leading off and not like talking on the topic.
Yeah.
Or we had somebody come up and introduce themselves, talk about their address, who their neighbor's with, and then they said, "Now my 3 minutes start." How do you do you interrupt people who are talking off, or is that break the procedure? How do you handle?
Oh, they wanted 3 minutes and 30 seconds?
Yeah, they wanted 3
Yeah,
minutes.
yeah.
But then there's also, the people who are talking about things that aren't related to the matter at hand. How do you interrupt them? Do you interject into their comment, or just let them speak for the 3 minutes and then just say thanks, but that wasn't relevant? How do you handle those?
Yeah, your staff and attorney will help with this, but I would just, if it's a 3 minute rule, the chair's going to lay the groundwork. Next we're going to open it for public testimony or public comment, whatever you call it. I want to remind speakers that you have 3 minutes. We ask you to speak to the application, give us whatever information you have about the application. I want to remind you that this is not the point where we as the commission ask questions or give feedback to people as they're giving public comment. We're just receiving your testimony. You have 3 minutes. I don't know if you have a shot clock. It's a nice thing to have a shot clock
We have a little button, little
that the
red,
applicant
yellow,
can
green
see. I think
button.
and I don't think, I don't think they get, yeah. And we don't want to be adjudicating whether they're during in real time while they're making comments, whether it was relevant or not. They just get their 3 minutes. Yeah. Yeah, you can see that rabbit hole, right? Well, I think it is relevant. Well, I guess if we go down that rabbit hole, that means then you get 3 minutes, right? And that's all you get. And you don't get an additional 20 seconds to introduce yourself. But we I get it from a citizen's perspective. It's tough, and they're feeling a little uneasy, and it's anxiety inducing, right? So the chair does those things up front to make people feel comfortable, but also remind them of the rules. Right, but I would encourage you all just to receive that information and not to go back and forth with them. Just let all the public testimony come in. Okay, that helpful? Yeah. Let's see, with regard to your own questioning, I think we've covered some of this stuff. Your questioning at the appropriate time in the hearing is you want to ask questions to clarify factual content, right? You're not asking questions about your own, that relate to your own personal views on the issue. You're asking questions that relate to the factual information that's being developed in the record and factual information that bears on the criteria, right? The reason I suggest that we wait until later is, again, I think it plays into the idea that we're the judges. We're letting everyone else speak and give us their testimony first. We're going to digest all that as the judges. We might have some remaining questions, but a lot of their questions probably get answered as the interested parties each hear each other's testimony and have their opportunity to put in their 2 cents. Make sure we're not asking leading questions, right? And that can be a problem early in the hearing as well, right? It's like right after staff report, and we start asking a question. Hey, staff, isn't it true that this developer defaulted on a subdivision improvement agreement in another community? Sounds like that person might be advocating against this developer for some reason unrelated to the actual criteria in the land use code, that kind of thing, right? Let's see. All right, I got 2 scenarios here just to kind of work through. I'd love to hear your thoughts on these. Actually, the first one we've already handled by my earlier example. What about the second one? From prior comments, it seems that one of our members generally disfavors additional gas stations in town. We have an upcoming special use, for you it's a special use hearing for a proposed gas station, and the member's been asking staff to include information about pollution and environmental impacts posed by gas stations in the packet, and has also been posting on social media about the upcoming hearing. What do you think? Is that concerning personal behavior with respect to the role of a quasi-judge, right? Doesn't that first activity sound a little bit more like advocacy? Right. So building on that question, well, what if I do have concerns or questions about environmental impacts or pollution, right? Well, first, let's look at our code and our staff reports, see if those kinds of considerations are part of our criteria. If they are, and you're going through the staff report, then jot down your questions related to that, right? So I don't know what criteria might come into play, but let's say one of them is maybe your code's this granular that for gas stations you have a fuel spill recovery plan requirement as part of your criteria, right? But you don't see it in the staff report. Well, then during the hearing, staff, hey, with regard to the criteria, that any proposed gas station have as part of its application a plan for fuel spill recovery. Where is that? Can we talk about that? Can we get more factual information on that? But otherwise, I think, and I had this situation and it came to light and, we got letters of objection and we had legal issues that pop up, and that was one of the quasi-judicial decision makers was basically saying, staff, put this stuff in the packet. I'm advocating against this thing, so put this in the packet. I think the packet is not complete, right? So, and then what about social media? What do you think about that piece? Yeah, I think the interesting thing would be, well, the citizen might rightfully be asking, why is this commissioner or elected official posting about this one hearing on social media? Seems a little bit like advocacy. Do we always post upcoming hearings on social media? Maybe they're trying to whip up support or opposition by their social media activity, right? So we have to stay away from that. Oh, and by the way, are you all active on social media?
I actually had a question about that.
Yes.
So it was the Revere property. So it wasn't in the board. It was a petition from the residents. But they had petitioned and they were posting stuff on social media. And my wife saw something and told me about it. I was like, well, that's a misrepresentation of the facts. And then she took it upon herself to post something. I told her to take it down later because of our affiliation. But where's the red line there? If she just posted basically hey, well, there are also considerations of facts and it's kind of arm's reach, but not really. What do you think? What are your thoughts?
It's a great question. Your significant other is entitled to whatever they want to do on social media. They're not the decision maker. The perception that can arise, right, is are they becoming a proxy or conduit for information, right, that's not part of the record, right? So it truly is a lonely part of the job, right? Sometimes you can get heat from the citizens. Oh, I saw the commissioner's significant other or spouse was posting. That must mean that the decision maker is biased or impartial, right? If that sort of perception bubbles up, or you can make a preemptive comment if it actually boils up to potentially infecting the hearing, But I would encourage you all, with regard to social media activity, if you're scrolling on social media and you see something about land use, quasi-judicial land use matter that's coming up, ignore it. Ignore it. Tune it out. The minute you see it, tune it out. Because why? Because we have a great process here. That's where I'm going to hear and learn about this thing. I'm not going to learn about it on social media, right? Do we agree that social media probably isn't the great place to adjudicate the difficult land use matters, right? And those people, they got their own view and they're working to whip up support and get the community. But hey, what do they got to do if they want to influence you? Come to a hearing or send in written testimony. And that's the great way that it's done. And that's the way that comports with due process, right?
And it's
So we have
hard.
to stay away from those parallel processes. It really is a lonely part of the job. But it's a misperception. People who want you to jump into that fray are misperceiving your role to be more like a legislative role, thinking that you have the ability, authority, and should be jumping in on social media saying, hey, I'm a planning commissioner and this is what's right and I'm going to correct the record and that kind of thing. Now, one way that organizations can help run interference for you on that is if you see that kind of stuff, particularly if somebody DMs you, right, or sends you an email, get that over to your planning department. They can reach out to that citizen and say, hey, you're not going to hear from the commissioner, but I saw that you reached out to them or tried to message them. If you want to learn about that application, you can go to our planning department website and we have public materials and that kind of thing. But the commissioners can't reach out. Yep. Okay. And so I've seen for some communities with the super high profile controversial land use decisions, sometimes they'll create and dedicate a certain, they'll end up putting on the home page of the website, click here for more information about whatever it is, Sunrise Ranch development, right? And that'll quickly take it. And then you can use that to your advantage, right? Somebody tries to reach out to the individual and say, hey, I can't talk to you, but you can go to our website and there's information up there. So, all right. Let's see. Thanks for that, because it ties right into, let's dig a little deeper on ex parte communications. So it is a critical job to stay away from ex parte. Simply means outside the hearing discussions with interested parties about the subject matter of the hearing. And I've listed some examples here. It means we as commissioners individually before the hearing, we can't be meeting with the applicant outside the hearing. Of course the applicant's natural inclination might be, hey, can I take you to coffee? Talk to you about my application. We can't do that, right? Or going to neighborhood meetings where they're, getting their strategy together about opposing or supporting an application. We can't do that, or even emailing each other, even individually, one-on-one, because judges need to deliberate about the matters under consideration at the public meeting, right? And so you shouldn't be emailing your fellow members to persuade them to go one way or the other on an application as well. That's what you do in the public hearing, right? So I know that's tough in the public hearing, particularly if you got a packed room and everyone's emotions are running high. But in your deliberations, one of the key little tactics is make sure we support each other, right? And that we're all co-equals here. We all respectfully listen. That if we're expressing a minority view of how the criteria apply and people are booing about that, the mayor's going to recalibrate by saying, hey, look, we're going to have a respectful discussion where each and every member gets to speak on their views of how the criteria operate. And we're going to be respectful about that because the job's tough enough, right, as it is in those situations. Okay. So on ex parte contacts, we just need to make sure, right, that we're staying away from those things because if there's evidence that the proceeding is loaded up with prejudicial ex parte communications, that's a clear path to having someone challenge your decision or challenging your participation as a decision maker, right? Let's see. Other potential ex parte communication issues that we talked about is Staff, I think we've talked about that. Was that helpful? Did we get that issue covered? Okay. What about, I know for most, you like most communities have a two-step process on quasi-judicial matters. You make a recommendation to the town board. Would it be okay for commissioners to reach out to town board members after the planning commission makes a recommendation? Yeah, you've done your work. Let your work speak for itself, right? Whatever the vehicle is you use to convey the commission's recommendation up to the town board, let that speak for itself.
So, just for more clarification on that piece.
Yeah.
So if we vote no on something,
Yeah,
it can still go to the town board for them to overturn our decision.
is that correct? Okay.
So we're not killing anything. It's just simply saying this is our opinion. It can still go to the board, and that's all it is. So we're simply
There's a
judging.
couple times when we're final authority or we make the final vote, but most of what we do goes to.
Correct. And so what we are really judging upon then is whether or not we believe the criteria has been met in order to move forward. And if the staff gives us a list of the criteria
Right.
and their opinion,
Right.
we can use our own understanding or interpretation of what the outcome should be for the town. We can disagree whether or not it met that criteria.
I like it
That
now.
is what we're judging.
Yeah, I would look at it in terms of analysis.
So
yeah,
that is where we have that power.
right.
So if we just simply agree with whatever the staff says, we're kind of more performative. We're not really deliberating. We're just kind of passing it along. If we
Well,
don't.
yeah, even for the
Where's
ones where it's clear that the staff, even if it's kind of what I call a no-brainer, staff report clearly meets all the criteria. You've heard all the testimony, and you're like, yeah, it meets all the criteria. Let's just make a motion. We still like having on the record you all, as the decision makers, making some comments, even if it's as simple as, all right, thank you for everybody's testimony. Good public hearing. I've looked at the staff report, reviewed the criteria, looked at all the information, and I want to let you all know as my fellow commissioners that I find that this application does meet our criteria, so I'll be voting in favor of recommending approval to the town board. I think that's a great thing to do. Yeah.
Thank you.
We kind of take the requirements
Yeah.
and we go through each one
Yeah.
and we look at staff report. And in my mind, that's our opportunity to really challenge the interpretation.
Right.
Right? Did it really meet the code
Right.
or did it not?
Right.
And I think that's where, if we all debate that issue, right? We've heard from the public hearing, the participants.
Yeah.
And if there's something that, as we're going through those requirements, trigger a question.
Yeah.
And we say, well, but did they really meet that requirement?
Right.
I mean, is it, it's someone's interpretation, right, that they met the requirement, and you debate that, and that's where I think that's where you either have an agreement or disagreement, right? You have to start with something, right, and something is the requirement.
Yeah. Yeah. And if there are differing interpretations of the criteria, then look to your staff. It's always your prerogative to say, staff, all right, on this criteria, what's the development code say, and how do we interpret that? What's your, right? And then they'll jump in, like conditional use height limit. Okay. Hey, what's the height limit? And how do we measure height again? Because the developer testified that they meet the height limit and the staff report says they don't. So what's the criteria and how do we measure that? And then staff's off to the races and explaining the 4 pages of rules about how we measure height, right?
And I think
Whatever
some
that-
things are more black and white, right? How many units per acre?
Yeah.
That's a code thing. And if you're allowed 10 units per acre and you have 9 units, that's not something they've met that criteria, right? And I
Right.
think staff would put it, if you have something in the comprehensive plan that says you need to have a adequate buffer zone, there's a lot of flexibility on what we think is adequate. It may only be 10 feet, but if they've
Yeah.
done 20 foot of planting, maybe we say that is adequate. Other times we may say, no, you're going to need 50. I mean, so I think that there's a careful between, because I've heard some comments, and again, this is over the last couple of years, the community is divided on height
Yeah.
and density, and whether we should have more residential and how
Right.
much residential and what type of residential. But most of that is pretty clear in the code. And
Driven.
even if I disagree and I don't think we should have 20 units per acre, that's not,
Right, that's not.
then,
Yeah.
then our role is when we adjust the comprehensive plan to revisit that question, right? What are
Yeah, or there are code amendments. Yeah, you're
well,
absolutely right.
We look at, we
Yeah.
say that we want to.
Outcomes on those issues are driven by pre-existing legislation, right?
Yeah.
The more things that you might deliberate more in your recommendation might be, and please and jump in, things like circulation. Is the trail and open space layout, right, the one that best meets the criteria? Those kinds of more nuanced types of things, right? I don't know if you've had others that have bubbled up in recent hearings.
No, in a recent hearing, though, Chair Sigmund actually did ask staff, can you please give us your interpretation of this particular
Yeah.
criteria?
Right.
And I think that's really helpful for staff to be able to set the record as well.
Yeah.
Why that interpretation was made. In the end, again, Planning Commission can disagree. However, just understanding what that interpretation is very, very helpful. And it's nice to be able to have staff answer questions when you're deliberating.
Right. We just have to make sure that if we're disagreeing, we're going a different direction, that actually our disagreement is a defensible interpretation.
Yes, I
Right.
guess that's,
And
that's,
that's-
a great way to
that's the
say it,
key.
because it's not
Yeah.
disagreeing with, we're not here to
Yeah.
just rubber stamp the staff report, as you
Right.
said. We are, but we
Right.
want to make sure that we're basing our questions or our opinion or our vote on actual standards.
Right. Right.
I think when I listen, a lot of times people will say, well, I feel this. And I'm more of a facts guy. What are the facts? We all have feelings and we have what we like to see, what we don't like to see, whatever. But what it boils down to is, what are the requirements? You know, black and white. Take the feelings out of it, put the facts into it, and that's how you start having a good discussion.
And I think you hear a lot of, I feel, I think, I've
Yeah.
heard. You know, I've heard a lot of people don't
Right.
think we should, I think we
Right.
need to be,
Right, and-
I think a lot of our businesses want this, you know, it's that
Right.
kind of stuff. It's, we're
Right.
gonna refer
Yeah.
it back to the.
Right.
Yeah, in terms of your deliberations, that adjudicatory tone, right? I find, you know, in my opinion, the evidence shows. The last two you mentioned, the I heard or the people want, that's a big red flag because that suggests that we're engaging in ex parte communications,
So,
right? Yeah.
But the comprehensive plan is basically an accumulation of feedback from the community that was created. Am I incorrect in saying that?
At one moment in time.
At one
Yeah.
moment in time. And so, but we are asked to utilize the other plans that we have as a way to kind of gauge or move forward. So I do think there's a nuance and there's some, for example, do those apartment complexes meet the outcomes that the town's looking for according to the, and if I'm looking at the comprehensive plan and if I'm looking at the mountain overlay, and if I'm looking at all these things, I say, no, I don't think so. But then if somebody wants me just to say yes, and they can say, well, they've heard, but you don't have to actually follow that. So I get a lot of that back and forth of like, well, but you can, but you can't, and I'm going, I feel like I'm being led to a certain decision, by saying you can ignore the comprehensive plan or no, you must abide by the comprehensive plan. So
Yeah.
I'm struggling with that piece in terms of, like you were saying, data. Do you want me to look at it or do you not want me to look at it? Do you want me to be subjective or interpretive about the comprehensive plan? Or do you not want me to? I'll do whatever you want me to. I too want consistency. And so I'm having a hard part doing that because if I'm doing different things at different times, then the process is flawed.
Right. So
Well, and
your staff may want to, this might be an additional session on how the comprehensive plans translate into the code. But there's a step in between there. So under Colorado law, a master plan is not regulatory. It's advisory. In a quasi-judicial decision-making process, you have to make your decision based on the regulations, the regulatory framework. So if you want the comprehensive plan to be regulatory, you've got to pull into the regulations those provisions of the comprehensive plan. So just to cut to the chase, sometimes I'll see this danger of all the criteria are met, But then we have a deliberation where someone opens up the comp plan and says, well, based on kind of these lofty visionary statements in the comprehensive plan that are too vague to be enforceable and that we never rolled into our code, I want to deny it. We can't go that route. We gotta look more granularly at how did we take the broad visionary stuff and translate it into specific criteria that are not unconstitutionally vague, that are actually right there in the code. So really to determine consistency with the comprehensive plan, you're looking at other provisions of the land use code that help make that more granular so that you can do an analysis. And that's why I said what we're doing is analysis. We are analyzing. This is my analysis. We want to get away from this is my opinion. We want to say I find, that kind of thing. Right, and it's always your prerogative to say, staff, explain your analysis.
Yep, and so on that, I guess two things. It is, yes, the comprehensive plan is a vision document. It's not regulatory at all. In the comprehensive plan, for example, one of the goals and in the action plan items of the comp plan was protecting the scenic resources that are in Berthoud. So then in order to determine how do we take that vision and make it a regulatory tool. So we've done some things about buffering. We've done some things about protecting watersheds, things like that help to protect the view corridors. So that's how you can take what's in the comprehensive plan and codify it for regulations.
Yeah, so if you've got to protect the view corridor and create buffers, so you've got certain setbacks. You got a developer who comes forward and says, well, I'd like to make more use of my property, so I'd like to, I don't know if you can make those kind of changes through a PUD process, but they want to move, reduce the setbacks through the PUD plan. Well, you don't want to say, I find that I move to deny because it doesn't meet this preservation of scenic corridors as articulated in our master plan. You want to say, no, I find that it doesn't meet that criteria related to buffering, which at the end of the day is serving the objective of the plan. Yeah.
And we have taken almost everything in the comprehensive plan that could become regulatory, and it is in our code. So the only thing that's not in our regulatory code is the future land use map. And again, that's a vision tool. And so that's the only thing that I think there's a lot of discussion around is that future land use map. Because again, anything that could have become regulatory, it did.
Yeah, I was just going to say, I think it's interesting, like Chair Sigmund had said, it's like not, the zoning code, the regulations is like checkbox, it's yes or no. Then you get to like comprehensive plan, and then there's sometimes, savvy ways to approach regulations that like might not fulfill the goal of the comprehensive plan and the vision of the land use map. And it's like that, it seems to me over the last year that I've been on the board here, is that at the commission, is that most of the time we're deliberating that. We're not deliberating necessarily specific zoning or regulations. It's like, is it actually like fulfilling what the people wanted and the intent of the master plans? And I, we've had those deliberations mostly in regards to regulation, but it seems to be mostly on the gray zone that we're usually having conversations. Not like, oh, this setback wasn't met. It's like we'd all vote no. But it's that comprehensive plan that we really are having those conversations.
Yeah.
I took a note down for our
Okay.
attorney.
Yeah. Maybe in terms of working through some, like in a future training, you work through and some hypotheticals, and you say, which criteria are we talking about? Which are the squishy ones? Because there are certain areas, as the chair mentioned, where the criteria are squishy, and you're getting in there and having a deliberation, right? But just again, from a risk standpoint, again, if we have a quasi-judicial application and the criteria don't support our decision, but we think the comp plan does, then we got a gap there that's creating the legal risk, right? Yeah. Anything that we want, well, I'm just beating a dead horse here, but if we want something in the comprehensive plan to help be the basis for an approval or denial, then it needs to be part of the regulatory framework. Yeah.
Again, I'm like you. I want it in bits and pieces, and I just want the rules behind it.
Yeah.
So for the warm and fuzzy things, it almost sounds like let's just pass it. The town can do the fuzzy stuff. But I'm saying that's kind of what you start to kind of run into with that particular piece, where it's that kind of gray matter. So.
Yeah, maybe it's a parking lot issue, because maybe it is. Maybe there's a, maybe it sounds like maybe there's some thoughts about our policy framework ought to be different, but that's a legislative activity, right? Not a quasi-judicial activity. Yeah. So, that helpful?
And we'll have lots of opportunity for legislative issues and discussions. We're part of formulating the comp plans and looking at the overlay districts and amending different things and walking through different areas. I think the problem is once they're adopted, once again, they're just because I don't happen to like the density requirements in the code, I'm stuck with that's the code. And if I don't like that, then it's amendment to the code and it's revisiting that topic with the town. And we had a referendum question that I think has some people confused because there was a fairly high voter for one direction, and people sort of think, well, I voted, so now it should go into action, but it's not in the code yet, right? So there's the
yeah, that can create some gaps between expectations and the reality of where things are at.
The public's expectation is, well, there was a referendum and people said they wanted this, so now why aren't you guys voting that way? It's not what the code says. That's just what.
One of the things I think that just comes to mind and kind of what we're talking about how do you take the comprehensive plan and solidify it into regulatory statutes or codes is those things that the spirit of the comprehensive plan is directing towards something, but then when we get to the code, we have to quantify it as opposed to just address it. So it's like we've had the conversation about, well, mixed use. That can mean a whole bunch of stuff. Yeah. Does that mean 25% residential, 75% commercial? Is it 50-50? Right. If there's not something to quantify it, then the yes/no answer as far as how you're applying the code is yes or no, but it's like it's almost ambiguous because it's like, well, technically yes, but it's because we haven't refined it enough to be able to dive deeper on the spirit of the comprehensive plan as it relates to quantifying it into a code matter.
Right.
And that's the first thing that comes to my mind is like the mixed use thing is like, what does that actually mean? It doesn't just mean more than one. Is there a balance that we would like to see from the spirit of the plan, and how do we quantify that in the code with numbers?
Yeah, and you get into all sorts of things of how granular do we want to get, right, in the mixed
Yeah,
use.
and you can go really deep on that.
Is it
right.
must have residential can only be residential over retail.
Yeah.
Right. What does design look like in fostering what we mean by mixed use? It's going through a regulatory process to articulate what we mean by mixed use. From an attorney's perspective, it's you got to do the heavy lift if you want to have certainty to effectuate what mixed use is, whatever that means to you, so that you can survive the challenge by the person who says, well, there was no clear meaning of mixed use, and therefore their decision, wasn't grounded in any.
Yeah, I just see that like mixed use looking forward, and I'm not trying to relitigate anything, be specific about anything we've done in the past. Just saying I could see that comprehensive plan and the code kind of clashing all the time when it comes to mixed use because it is such a big bag, So.
Yeah, and
But is that?
it's almost like difficult to quantify everything.
Yeah.
And that's, I think, where it's like we mostly deliberate the comprehensive plan and future land uses because it's like we can't just like say this is exactly everything. Like, that would be a waste of the staff's time.
And plus, I think, depending on the property, right? I mean, depending on what's being developed. I mean, to put a number on something and apply that across the board, I don't think is reasonable.
Yeah, and I don't.
You have a 100-acre property that's being developed, and you have a 5-acre. It's a different conversation.
I think that's where subjectivity comes into play, because we could have different definitions of what that means.
Right, and I think that's where our discussion, I don't think we're gonna get in trouble with any decision we make on that. It is gonna be somewhat squishy, as long as we stick to what we're hearing at the meeting, following the, you know what I mean, going through those criteria and not kind of going off into personal,
Right.
you know.
Feelings.
Yes.
Right.
I'd like to see
ideas.
shorter buildings, well, that
Right,
doesn't
yeah.
matter, but if, you know, I think, so I think we just, if we're careful there, as you said, our vote's it's gonna be tough to overturn a vote if we followed
Process.
the process.
Right, and applied our criteria. Yep. And I
And
got
applied our
Yeah, and I've got
criteria.
an example in a slide or two that talks about in a quasi judicial setting how we get to granularity that helps us make a defensible decision. I don't have all the answers for you on what it sounds to me like a bit of a question of legislative. Where do we want to be from a legislative perspective? Okay, just to wrap up on the ex parte piece. Just make sure and staff can help you with this. If somebody reaches out to you, whether it's in person or by email or what have you, we don't necessarily bring this on ourselves. Sometimes the citizen will try to contact us. Just have some talking points ready, and remind them it's not that I don't want to talk to you. It's just that I can only engage with you during the public hearing. And usually they go, "What? Why not? I thought you were one of my town officials. Why can't I talk to you?" And again, it's not that I don't want to talk to you, but to be fair, I need to wait until the public hearing. If you can come to the public hearing, we'd love to hear from you. If you can't come, please send in written material. What do you mean I can't talk to you? I've found over the years that it works. It's helpful if you flip it around and say, "Yeah, I get it. But wait a second. If this were your land use application, would it seem fair to you if the judges were talking with people opposed to your application outside of the hearing where you couldn't hear what was being discussed and didn't have a chance to respond to that?" We get it. That's what due process is all about, right? And so that's why it's critically important to have some tools. If it's an email that you get, I would encourage you, you don't get many emails, do you? Okay, if you ever get one, just forward it on to staff. They'll take care of it. They go through a process to determine whether those emails have to go into the packet, right? They can also reach out to the person who sent the email and do a little public relations for you. Say, hey, I know you sent an email to the commissioner, but just on their behalf, I'm reaching out to you to let you know that you won't get a response from them, but here's how the process works, Or if you feel like you need to respond to the constituent, say, hey, thanks for the email. Just want to let you know I forwarded it on to our planning staff, and that's all you got to do, that kind of thing. Okay. Sometimes people ask me, when does the prohibition on ex parte communications kick in? Do you have a bright line rule on that? Okay. So here's just to illustrate the problem in this area. Sometimes I would hear from the applicant, developer interests that the ex parte communication, the restriction on the commissioners or the town board talking to me about my application only kicks in from the day I have the application filed. Before I file an application, they can talk to me. It's just not that bright line, right? Well, the developer calls you and says, "Hey, would you like to have coffee today?" And sure, I'll have coffee. I just want to talk to you about your broad views of the town. Hey, that's okay. That's kind of it. And then you go to coffee and they say, "Oh, thanks for your feedback on your vision for the town. I'd like to talk to you about this property I own, at 101 Mountain that I'm going to redevelop, and I just want to hear what you think about that." That's when your radar's going off. Say, no. I'm not going to engage with you about any sort of discussion about something that may come in front of me as a commissioner through a quasi-judicial process. And if they profess to not get that and they're a sophisticated developer, I don't buy it, right? They're just trying to get to you early, and that's developer risk. If they want to hear what you think of an application, then they need to file an application and go through the process. But staff can give them lots of great feedback on, what the town expects and what our rules are and what kind of development we want, right? They're there to do that heavy lift for you so that by the time the application gets to you, it's hopefully one that's pretty close to the mark about what we want as a community, right? So, but do recognize that those one-on-one discussions with applicants can run afoul of the ex parte rule, okay? All right.
Quick question.
Yeah.
So, because we are also citizens, if there was
Yeah.
a situation of something that you knew was going to come to the commission at some point in the future, but it was a particular thing that you were really passionate about,
Yeah.
could you be involved and proactively say, hey, look, I'm going to advocate for this, but I'm telling you now ahead of time, I will be recusing myself from this matter because I want to get involved as a citizen?
My short answer, please check with your staff on this. My short answer is you could do that if you wanted. So go ahead, but you got to recuse yourself.
Right.
Take yourself out of it.
Right.
But the two questions that come up, if you're thinking that you still get to appear before the commission and advocate on behalf of that interest, I think that's a conflict problem.
Yeah. No, I think it's more of like outside activity.
Yeah,
of
and
like
then outside
helping the
activity
cause.
as well. You have to be willing to take on this heat under the perception issue, which is, I thought that person was appointed to do the work of a planning commissioner, right? And so if we're, particularly if we're doing it, I'm passionate about affordable housing or high density housing, so I'm going to get involved in all that, but that leads me to have to disqualify myself on numerous applications, right? Are you giving full value to those who expected you were going to have full service to the commission, right?
That's a good point.
Yeah. So that's something. Yeah, and I'll give you here's a great real life
thinking like
example. I had a
something
board
very
member who
minute,
was a
not
real
broad.
champion of the community food bank, and this municipality owned their former town hall was just a small residential house. They finally grew up and built a town hall, but they still own the old house. And this elected official said, "Well, wearing my advocate hat, I think we ought to use that. The community ought to use that new town hall." That old town hall as a food bank. So we advocated for that, lined up support, tried to get funding, helped coach the other people about how you get through the town board process, right? And then he showed up at the town board hearing wanting to be one of the decision makers on this special review use for the new community food bank. Right? The rest of the board, number one, staying aside from the legal issues, was not actually particularly hot on this conditional use. So that member got way ahead of his colleagues on the issue, right? But then at the hearing, he also had this conflict question, disqualification process problem because he wasn't fair and impartial, right? So, yeah, the slide actually mentioned that issue about is the idea of being, working on matters that may come in front of the commission, is that consistent with the expectations of being a commissioner, right? So, I think legally it's possible to do it as long as you do all the right things around disclosure and transparency and so on and so forth. But there might be that other piece as well. Yeah. Okay.
Well, I don't have time to do anything else. So
All right. I just wanted to point out this scenario as a segue to something else real quick. So this is, in this scenario, Commissioner Nile, he's unable to attend the Planning Commission meeting next week where we've got a public hearing on a special review use for a group home. Over the weekend, he emails another commissioner to tell her she should vote no. That other commissioner then responds back to Nile and copies in another commissioner telling both of them that the number of proposed bedrooms is a huge concern. And then the other commissioner who was copies in both of them and says, hey, there's a lot of social media buzz going on about this. People in the community don't want this, and we shouldn't be approving this kind of thing. Do we have problems? Yeah. So there's a couple things going on here. But the one question I want to ask you is, if you're going to be absent for a commission hearing, is it okay to give your thoughts and views to a fellow commissioner who can express them on your behalf? My answer to that would be no, don't do that. Right? It's a must be present to win for everybody, or must be present to participate for everybody, right? You'll hear that from public comment people too. Sometimes someone will stand up and say, oh, I know I only have 3 minutes, Chair, but actually I'm here on behalf of my 5 neighbors as well, so I'd like 18 minutes. Must be present to participate, right? Unless you have some special rule that I'm not aware of. The other thing going on here is obviously an open meetings concern, right? So be careful of that issue as well, right? Remember that you are subject to the open meetings law. It applies to any of the work that you do as planning commissioners, right? Whenever 3 or more of you want to discuss business of the planning commission, that has to be an open meeting. But the additional higher standard for under the due process clause as it relates to quasi-judicial matters is don't even have a one-on-one discussion about the merits or substance of a pending quasi-judicial decision. Save your deliberations for the hearing room. All right, let's talk about ethics real quick. Just remember that you are subject to the state code of ethics, right? Do you agree with this notion that ethics codes kind of seem like they're written in legalese? You know, they're kind of in this faraway place because they are. There's this, here is a statutory town, you follow the state ethics code. But my best risk management suggestion is just to get a good working familiarity with what the rules require so that we have a good understanding of what an interest is for purposes of a conflict of interest. It's a little fuzzy, right, under the state code of ethics, right? If the commission is going to take some action, and that includes a recommendation, right? If the commission is going to take some action that directly and substantially affects my own personal financial interest, then I'm in a conflict of interest situation, right? And I have to disclose my conflict of interest, recuse myself from the commission's discussion and vote, right? Do you leave the room when you have a conflict of interest?
Front row.
So, yeah.
What's that?
You sit in the front row.
Sit in the front row with your arms crossed, or if it's a good comment, you do this. No, we don't do that either. You know, it's interesting. The state law is silent on whether you have to leave the room or not. I would look to your attorneys for a suggestion on that. I would think in terms of service of your fiduciary responsibility, think about this. Would it be fairer to my colleagues if I had a conflict of interest? Would I feel like I'm enabling them, their ability to have a fuller and freer discussion if the person with the conflict were not in the room, right? And then you may be thinking, well, that's unfair. I have a constitutional right just like anyone else to deal with my own property affairs. I need a variance. Why can't I recuse myself, sit in the front row, and then answer any questions that come up about my variance request?
We would ask them to fully leave.
Yeah, okay. Well, you could do it, but I just want to report the danger to that is the last part of the state ethics requirement is that you not attempt to influence your fellow decision makers. So that's a good time to have somebody else represent your interest for you, right? So keep an eye on that. You probably don't get confidential. Oh, yeah.
Is that something we could get a copy from you guys? Sounds like there's a particular document or something.
Oh, I bet your town attorney firm's got some information that would be helpful. Put it,
Okay.
yeah,
I
they
wrote
get
it
you both the
down.
rules
Okay,
and
thank you.
some summary that helps put it in more useful terms. Sometimes it's a little fuzzy, like maybe you live in the neighborhood and you're wondering, well, I live kind of close to that property that's the subject of the application, but how close is too close, right? So here's my suggestion in risk management. I hope I don't speak out of turn for your staff or your town attorney. I think they would prefer call them earlier than later, right? They can't serve as your personal ethics advisor, but it's much better to call them and ask, hey, how does the ethics code work? Can you give me your feedback? Again, they can't be your personal ethics advisor, but your town attorney in particular can give you feedback on how the code is supposed to work and what the expectations are under the code. Much better to have that conversation early and think through the issue than have an ethics issue unfolding for the first time in real time at the public hearing. You know, you get to the hearing and somebody stands up and says, Chair, before you open the public hearing, I'd like to make an objection. I'd like the planning commissioner to disqualify himself because I think he has a conflict of interest. And now we're going to have a little mini discussion on the record, right? So be careful of that issue as well. Obviously, there's gift rules that apply. Obviously, don't accept gifts from people if it's clear to a reasonable person they're offering a gift to you, you know, to get you to depart from the fair and impartial discharge of your duties, right? And then last thing is, do you agree with this notion that in matters of ethics, you know, sometimes perception equals reality, right? And reality equals perception. So I would encourage you, because, you know, what really happens almost all the time is the commissioner or the elected official does the hard work. They figure out in advance what the rules are, whether they need to recuse themselves, and they've done all that work, but the people who might have a beef with them don't know that, right? So you get to the hearing and there still feels like there's a cloud, like you're sitting there, you're getting ready for the hearing, but someone's still staring. Why is she up there? I thought she had a conflict. She shouldn't be voting on this. So what I don't underestimate the value of what I just call a curative disclosure. You know, maybe you say to the chair, hey, Chair, before we proceed with the hearing, I'd just like to make a statement of disclosure for the record. You know, I just want to address the fact that I've heard some suggestions or some rumors that I have a conflict of interest and I need to recuse myself. I just want to let everyone know that I've consulted with staff and the town attorney, and I do not have any interest, financial or other interest in this matter that requires my recusal. And then the really important piece is, and I just wanted to make sure that that was understood and also emphasize that I intend to make my decision and to review this matter solely under the standards and criteria that apply and make my decision based on the rules that apply. What a wonderful thing to have on the record, right? In my world, if somebody's got a problem with that, they better stand up and say, I disagree, and here's my evidence, right? Otherwise, we have on the transcript and the record, you know, of course, it's all got to be true and we got to walk the walk, but that's a nice thing to have on the record. Builds faith and trust, right? Okay. Appearance of impropriety is also a factor with regard to perceptions. There's no definition of appearance of impropriety in the state code. The body that enforces the state ethics code, the Independent Ethics Committee, they define for themselves, for their own members, they define appearance of impropriety as conduct perceived by a reasonable person to impair the ability to carry out official responsibilities with fairness, impartiality, objectivity, and integrity. So if you ever feel like that you're in a situation where your conduct, in your own view and in the view of a reasonable person, puts you in a place where it's creating an appearance of impropriety, right? You just have to make the tough call of, am I going to bow out, right? And, respect that concept? Or am I willing to, get in there and make sure I make the disclosure and just deal with that issue? Sometimes where it arises is like, we'll have this question of no conflict, but the suggestion is, hey, that commissioner or elected official, they're personal friends with the applicant. Right? Where do we land on that kind of issue? Right? All things to think about. So the only takeaway from a risk management perspective is just think about it early, work through the issues early. So any questions on that stuff? Okay. All right, we're just about done. After the hearing, we've talked a lot about this to your questions, so thanks for the great questions. But let's talk about deliberations a little bit. Deliberations is the magic part of the hearing, right? Where you're done with all the presentations and now you're going to come back, and this is where you as the decision makers, you're going to connect the dots using the formula of this is the facts, these are the facts that we've learned in the hearing, these are our legal standards and criteria, and that's going to help us arrive at our decision, right? Couple of magical things are happening. When you deliberate, that's where the applicant and others are getting an understanding of why you're going to make the decision and the reasons for your decision. That's where the judge is going to look in the transcript of the hearing to figure out why you decided the case the way you did, right? That's where the people in the audience get an understanding of what's going on. So, as I mentioned earlier, take that time, have good supportive deliberations, make sure we focus on the relevant decision-making criteria. As mentioned, we have to set aside personal preferences, including you have to set aside irrelevant or non-existing standards. Right, we got to apply the standards we have, not the ones we wish we had. I could vote yes, as long as the developer puts in an EV charging station in every unit. Well, if we don't have that criteria in our code, then it's not it's not grounded in authority, and that's really the code we wish we had, not the code we currently have, right? That kind of thing, right? As we mentioned earlier, you already all hit on this with your own comments. We have the staff report as a checklist. If we have questions about the criteria, then we do that, right? I encourage you to use what I call Sam's rule of why to help you get to a good place. Oh, by the way, when you deliberate, you have to also consider the weight and credibility of the evidence, right? Because not all evidence is the same. We agree? Going back to my traffic study, what if the staff and the developers experts all testified that the traffic criteria was met, but you know how it goes, the neighbors, rooms packed with neighbors who say, I drive by that intersection every day, and if you approve this development, then in my opinion that intersection is going to be a disaster. In my opinion, you must turn down this application. That's their testimony. Is that testimony the same, entitled the same weight as the expert testimony? It's opinion testimony. And I get it, and I appreciate the citizens showing up to provide us that testimony, but it's not fact driven. It's just an opinion, right? It's personal opinion testimony, and it's not adding additional factual information, right? So, again, as mentioned, you can try to draw out from that person, hey, give me more, facts that cause you to arrive at your opinion. But otherwise, you have to give that opinion testimony the appropriate weight. And if you're dealing with expert testimony versus mere opinion testimony, then the expert testimony has to be given greater weight.
Okay, but I'm just going to stop you, because if that's a citizen, we're not having a back and forth drawing.
Yeah.
Right.
Yep.
You're not encouraging us
No,
to
I'm
do
not.
a back and forth debate with people.
No, I'm not.
Sorry.
Yep. All right. Do you agree that sometimes the criteria can be a little squishy? That's good. Gives you some flexibility, right? But one of the things you want to do is you want to make sure your discussions, your deliberations are granular. And I would encourage you to use what I call Sam's rule of why. That'll always help you get to a fact-based, defensible decision. So do you agree, right? There's something wrong with this? Right? Let's say that's our special review use request, right? And, we had a hearing on this and we bring it back and the chair says, hey, great hearing. Let's start our deliberation. And I say, Chair, I'll start the deliberation. I'm going to vote no because I don't like it. It's a little bit of a rocky start, but we can get there. Just why don't you like it? Why do you not like it? Well, Chair, I'm going to vote no because I don't like it because the applicant didn't donate to the Christmas drive last year. That's when staff's going to throw the red flag, not an applicable criteria. I'm going to vote no because I don't like it because it doesn't meet our standards. Are we done? Why? Why doesn't it meet our standards? Okay, I'm going to vote no because I don't like it because it doesn't meet our standards, and in particular, it doesn't meet our special review use design standards. Are we done? One more rule of why. I'm going to vote no because I don't like it because it doesn't meet our standards. In particular, it doesn't meet our special review use design criteria because those criteria require that the proposed development be compatible with the neighborhood, and this thing is not compatible with the neighborhood. Why? One more time, right? And now you've finally gotten down to the design standard. I don't know if you have it or not, but the one that says within this mixed-use development, the design standards for the overlay for this particular use require pitched roofs, right? And centered base consisting of stone and glass, and we've got this instead. So that's why it doesn't meet our criteria. So that'll always help you get to a defensible decision, okay? We've talked about these.
Quick question on.
Oh, yes, sir.
It's not really specifically on deliberations in particular, but, and I think I know the answer to this, but I want to make sure, because I have served on various boards and some of them are government, even at a federal level, and they all have different things about them. Does this commission ever go into executive session? Okay. That house might look like a Weld County house and fit the neighborhood standards. Sorry.
What's the one that some people bandy around? The city of Houston, I don't know if it's still true, but the city of Houston doesn't have zoning, right? I think that was always one among the planners. And so,
Well,
hey,
they have a lot of tornadoes.
there you go. Yeah, right. You can hide it. Hide it. What's the landscape plan for that thing? Right?
Trees on the roof.
I think we talked about conditions. It's not on the slide. I just want to make sure, well, there's a little bit about it. When it comes time to make your motion, get together with staff and your attorneys and figure out what's our protocol for making motions. If we're adding conditions, make sure the conditions that we're proposing are clear. You know how that can unfold sometimes, You ask for a motion, you say, I make a motion to approve subject to the conditions that are listed in the staff report, but I'd like to add one more condition saying X, Y, and Z. And okay, you do that, you get a second, and then somebody says, I'd like to make a friendly amendment to that motion to revise that condition. And then we're having a discussion about what are we working on? What's the language, right? So particularly if it's late at night and we're not sure, the chair is going to lead. All right, let's make sure we all understand what we're voting on. And particularly with very high risk conditions, let's make sure we check in with staff and the attorney. Is the condition clear? Is it what we want to be, right? We don't want to have anybody can have this, but it's either staff or you or the applicant have conditioner's remorse the next day, where we read that condition and we thought it was a good idea at 11 at night just to get through this application, and then the next day we go, I'm not sure what it means. All right, yeah. So one of the tools, and please chime in, is I don't know if you use that often, but if you really have, particularly for super high stakes ones that lead to that's the ones that lead the claims. If you need more time, right, to get the conditions just so, then it's always okay to do a continuance to a future meeting. Say, hey, staff, could you work on the conditions and bring us back the language so that we know exactly what we want to put in this motion, right? Okay. Let's see. I think that's it, really. Unless there are topics that I didn't touch on that you'd like to ask me about. My wrap up, I know Ann's got a couple of other things to talk about, but for my wrap up, I just want to circle back around and emphasize the point that being a quasi judge, probably the most important product that you deliver is good process, right? So embrace good process, right? And legally, from our perspective, risk wise, again, recognize that if you're making the right decision for the right reasons through a fair and defensible process, applying the right criteria, then your decision is going to be upheld, right? And as importantly, people are going to have faith and trust in what you do, right? And that's a great place to be. So, you have any
Can I ask you a question about CIRSA? Kind of back to what you were explaining at the beginning
sure.
about what you do. So do you guys offer insurance to metro districts as well and other special? You mentioned some special districts, but you said you covered 200 and some, which leads me to believe there's a lot more metro districts in Colorado than that. So.
Yeah, there are. And I used to be the general counsel for the special district insurance pool.
Okay.
We only insure a special district if it has a connection, an affiliation with one of our municipal members. So there are 272 or 273 municipalities in the state. We insure about 90% of them. Most of our other members are municipal created entities, like regional housing authorities, E911 authorities. We do insure just a couple of special districts that are fire districts, but that's because they have that affiliation with the municipality, whereby IGA, they serve as the municipal fire department as well. And we got a couple other one-off entities in law. But if you want the historical background, because our firm, before I was at CIRSA, I was in a law firm where we were involved in all of this. In Colorado, we basically have 4 public entity self-insurance pools organized around types of government. We have the municipal pool, which is CIRSA. We have the special district pool. The counties have a set of pools, and then the school districts. Yeah, and we kind of all work together to champion municipal interest and kind of do our thing in our lane. So. And there are things that the legislature does that affects all of us, where we partner and we do sort of cross support every now and then. Like I've spoken at the special district conference, and we've had them come talk to.
So you said you represent about 90% of them, which means that even though you're statutorily created, it's not statutorily required that a municipality gets their insurance needs through CIRSA.
Correct. Yeah, the 90% is we insure almost all small to mid-size, almost all to mid. The largest of the large, like the Denvers and the Colorado Springs, right, are not CIRSA members. Frankly, in a pooling, a self-insurance pool, if you analogize it to a private sector, it kind of be like a mutual insurance company owned by its members, right, and controlled by its members. So a Denver or the Colorado Springs would probably be too big for pooling, right? Yeah, thank you for the question. Appreciate
This
it.
may be too granular, and you could just say it depends, and you have to read the docs. So I come from Illinois and IRMA, and I served as the IRMA chair for 10 years. But IRMA covered zoning decisions, and a lot of insurance pools, I think municipal ones don't.
Yeah.
Does CIRSA cover zoning decisions, or is it limited in what type of zoning? And I know there's these arguments on, the religious one you brought up. If a town is just going to discriminate because they don't want a mosque and they say no to it, there's a lot of pools that don't want to sort of be, they can't really remedy the situation, right? The pool can't say, no, we're going to force you to approve the MOS. So it puts this, so how does CIRSA work that? Since obviously if we have a
Yeah.
bad zoning decision, is
Yeah,
that
great
something you
question.
guys cover?
Oh, no, I'm happy to address it. So if the challenge is the state challenge, the 106 number,
Yeah,
we provide sublimited coverage for defense of that claim, defense only,
okay,
where the member has to turn the claim in to us. We will then hire one of our panel attorneys to provide defense up to a limited amount of coverage dollars. That's currently $15,000 per claim, 3 claim aggregate per year. The sublimit there, by the way, those 106 challenges are on the record challenges. I know that sublimit sounds low, but basically what you're doing is just amassing the record and putting it in front of a judge and making your legal argument. So we provide that defense. And then if it's a civil rights claim related to a land use matter where the person is making a claim for money damages as well, then we will in all likelihood defend that, but under a reservation of rights. Okay? Because we do cover Section 1983 claims. So
Okay.
if we have a PUD is turned down or religious use is turned down, and it's a civil rights claim for money damages for violation of equal protection or volupula, then we'll provide defense for that. But the twist, borrowing on your scenario, is if the decision makers, however, were out, intentionally violating constitutional rights, such that they don't have qualified immunity, and it was intentional malicious conduct, then we'd be invoking our exception, right, for malicious acts or willful and wanton conduct. Yeah. Never happened
Okay.
in the 40 years we've been around.
I've seen a few in Illinois. So.
All right. Well,
Well, and I've seen your kind of comment about kicking it, that I've seen elected officials sort of go, there's too much heat on this, let's just say no and let the courts overturn it.
yeah.
They don't want to, it's like this way we can go, I didn't vote for it, but they know they're violating the law, they know they have to approve it, but they don't want the political pushback, so they just go, let's vote it down, and if the courts overturn it, then we can say to our residents, well, we didn't have a choice. And that gets hard, because a lot of times it's not financial damages, they want the use there.
Yeah.
And the insurer can't compel the municipality to reverse the decision.
Correct. Yeah.
Okay. I just wanted to know what you covered
That's what
with
goes on in
relative
Illinois.
to zoning. Oh, there's
That's
a
what
lot that goes
on
in
in
it.
Illinois.
It's not exactly the
We're
shining
holding
example
faith-
of the way
we're
to do
holding faith
things
that's,
and right.
That's not. Yeah,
You're making
we're-
an attorney squirm over
We're all in
there.
good faith
There's
discharging
a lot
our
of fun stuff
obligation.
going on in Illinois.
Exactly.
Yeah, there's a lot going on.
There's a lot not to do.
Thank you.
Well, thank you
Thank
so
you.
much.
Thank you for your-
Every time
Yeah,
we
I'm gonna
hear
stick
these,
around. Is there any other questions?
yeah, but every time we have these discussions, I know I learn a little bit more, and I put it back together, and it just helps me, So hopefully everyone else gets a little bit out of it, and after 2 or 3 of these, we're almost experts. Not quite, but
And then our terms are up and we get to
Yeah.
move.
Yeah.
Yeah.
Well, and we do this training with CIRSA about every 18 months. So there might be new topics and new individuals, and it's always good, even for staff, to have reaffirmation of, all right, we're on the right track, or there are these other questions we need to regroup on. So it's all good. I have 12 slides. 3 of those 12 contain questions that have been picked up over the past year that you all might have. The majority of them have already been answered. So are you okay going ahead with the 9 slides that might be new stuff?
And by the way, just one other thing, I think since my time on the board, this whole process has been refined more and more. Every time we get together, it seems like it's getting tuned a little bit more, and it's a better process. So that's at least my piece. I've been here almost 3 years, and that's what I've seen from the process. So.
Well, thank you. Yep, it's always a process of continuous improvement.
Yes.
So thank you. All righty. See Daisy. Okay, so again, we've seen this slide before. So now we're down to 8. So we're working with the community to establish that clear vision. And Commissioner Butis, you asked the question about how do we take that comprehensive plan and put it into a regulatory document, and I believe Commissioner Filio, you also asked that question, and that is in the back of the comprehensive plan you have the action plan, and so that action plan gives us direction on how do we implement what's in that comprehensive plan into our regulatory documents. So, sorry, thought I might sneeze. So that is how we take that vision. Excuse me.
Bless you.
That is how we
Bless you.
take the vision. Thank you. And put it into regulations. Then again, establishing those regulations that achieve the vision and consistently and equitably apply those regulations. Does every regulation work? No. That's why we amend. That's why we discuss things internally. We're talking about interpretation. We're talking about, does this work? Is this the intent? So after every meeting, we're actually talking about, does what we're doing, is it working? Alrighty. So again, you've got an e-notebook and the slide deck and the wonderful handouts that Sam provided tonight are actually going to be put in your e-notebook. I'm sure Bella will do that. I know she's out next week. However, she'll do that the week following. So you'll have the most current information in your e-notebook. And Sam, this is a tool that we developed. It's online. And it's just called the Planning Commission e-notebook. It's tied to our website. And so we have all of these resources there. It's open to the public. If they want to look at it too, they can, but it bundles everything together. So again, the regulatory and legal documents are the Land Development Code. It's the purpose, it provides a criteria for approval, the zoning map, and intergovernmental agreements. Then process and procedures are master planning, development review, and the public hearings. Alrighty, so common regulatory and visual tools. Regulatory, zoning. It's a set of local laws that say you must do this. Subdivision, regulatory, you must do this. Building codes, regulatory, you shall build this way. Master plans, comprehensive plans, vision. It's, do you generally do this? Here's what we'd like to see happen. And then when it jumps over to the regulatory side, now you must do this. Do you have any questions? Sam did a great job talking about the difference, and I've taken some notes down for our attorney to talk about the comp plan with you all. All right, our favorite map. This is the future land use map. We have a lot of agricultural area that in 2019 to 2021, when the existing land use comprehensive plan was adopted, the vision for the town. And what would we like to see in certain areas? And this map really should be based on future growth and where do we have the capability to serve water, sewer, stormwater, roads, other infrastructure. Where is density wanted? And as you can see, Berthoud has grown very close in. We don't have a lot of sprawl. We did go out to I-25. We did that as well as every other community did it in the late 90s. We did it too. So we did go out and grab some area out at I-25. However, most of Berthoud is developing in a very tight format, which helps with utility and service provision.
Director Johnson, just
Yes.
to jump in real quick. I think the challenge I have is that like regulatory is like backward facing and like the comprehensive plan and vision documents are like forward facing. So sometimes we get something that like meets everything that we've agreed, but then like everything that like we want to go towards it might not like achieve that. And that's kind of, I think, the sticking point for me is that, you know, like, how do you balance that? I know this isn't regulatory, but it's like where we want to go. And if it's like we get a matter or a use application and it's like meets everything that we agreed on, but like doesn't go where we want to go, I think that's like the challenge that I face.
Yeah, and I think our biggest sticking point, again, the action plan in our comprehensive plan, more than half of that action plan has already been implemented. Another maybe 10% is being implemented this year, including a branding plan or, you know, things that don't have to deal with land use. However, they are being implemented by other departments. So anything that is land use related in our comprehensive plan was actually rewritten into our code. And last year we completed about a 14-month process of reviewing the comprehensive plan and making sure that the vision of the comprehensive plan is actually written into the code. So the only thing that really is, I think, even the town trustees struggle with this is this map. And I think because everything else in that comp plan that was visionary is in code. And we can guarantee that that's happened. It's this map is a problem and it's a sticking point. So I've got it on my list.
I appreciate that answer.
Yeah.
And you all have been doing an incredible job getting the comprehensive plan into the regulations. So thank you for that.
Yeah, you're welcome. And next year, when we look at some other parts of the comprehensive plan, then the following year we will rewrite what we just rewrote.
Can I just say something?
Oh, please.
I would say that's the nature of planning. And I think that's why we enjoy planning. That's why we're planners. Is that it's this ever evolving. And there are those scenarios, like some of which we talked this evening about, like the view corridors. That there's mention within our comprehensive plan about protecting view corridors. And really, there for a while, some of these things will be sitting in our comprehensive plan, but they never come up in the conversation of land use because they just haven't gotten there yet. And so, same thing with like mixed use. I think there's just these moments where we're like, oh yeah, we all got this, we understand what this means, and then we have this one scenario that then's like, oh, we don't know what this means. It brings it to our attention, and it's like, okay, we should probably define that. And we see things on the regular when we're working in the code and we're looking at things that, you know, we see something that just seems off, the word is off, and it's like, oh, you know what, we never looked at it this way. And so we're constantly, it's always an evolution, and even though we just did a code update, we see things and we take a note of it, and we have sticky notes, and we have notes everywhere. And so then when the time comes, in another year or 2 years maybe, we'll then go through that process of amending it. And so it's just always this evolution, and sometimes some of these matters, like I think the view corridors have actually started to come up a lot more. And it's like, oh yeah, well everybody really wants this. Unfortunately, there's really nothing solid in our code yet that then gives us this defined standard to hold people to. And so we recognize, of course, we should probably look at that, and we should really start to define what are our corridors, which then requires that we do a little bit more research and likely hire maybe a consultant to help us figure out through public engagement what those things look like. So that's the fun part of planning, and we're lucky in that we work in a small community where we, doing development review, which is my primary focus, I also get to do long-range planning with Anne. In a lot of communities, you don't get that. Once you're in a bigger community, you're either long-range or you're development review. You don't get to do the big crossover, so that's what's fun for Anne and Bella and I, is that we do. And so it is an evolution, and so we like finding these things. It's fun to then sort them out and as we go. And as we grow as a community, our code also grows up. How do you handle the conundrum with what you brought up, Commissioner Filia, of let's say you have it in your mind that something needs to be fixed, and you're like, okay, the next time we review the code, we're going to update this or we're going to define that. But what if in that in-between time, a big building wants to come in, it meets current code, and we say, well, we just have to let it be built, but yet it's ruining the opportunity. We don't have the time to fix the code before that happens. Like, how do you deal with those types of things?
I think it's case by case,
That's a
and
good
you look at
question.
that priority, and again, is this starting to become more and more of a conversation? And then it's talking to those applicants, and it's like, okay, we concurrently need to like look at, so one of the corrections, we did find an error in our code this last go around that had to do with lot size, and we recognize it was impacting not only this developer but likely others, and it's like, oh, that's a pretty big error. We need to work on that concurrently because that's going to cause problems. And so that was happening while this project is going through the review process, because luckily in that case, review of land use application takes a significant amount of time. So often I would say, but Ann can add to this, but I would say because those processes often they both take a bit, that's a fortunate component because then we can be looking at things concurrently.
And if there's an emergent legal reason why we need to change the code immediately, we are going to do that. That though also creates a problem because the publisher of our code, Muni Code, we adopted the new land use code 11 months ago. We just on Monday, 7 months ago, we just on Monday received a draft to review. So if we continue to amend the code into small bits and pieces, then the code becomes very unwieldy to manage. We've had a red line version of the code, and it was composed of 3 years of edits and track changes in different colors to represent what year and under what ordinance everything was done. And then it got published, and then Muni Code has still been wrong. And then we published, the clean version that was adopted December 11th. And staff has been utilizing that 300-page PDF that has no tabs, no searchable ways to do it for 7 months, and we just got a copy. So just because we want to modify something, we also have to take a look at, well, what is the management of doing that modification? And that's why we repealed and replaced the entire land use code last year, because we didn't want to piecemeal it anymore. It becomes a management issue. So Tana's right. We have the town trustees voted to increase the buffer and the view corridor along like watersheds and lakes and rivers and bodies of water from 150 feet to 300 feet last year. One of the things that people continue to talk about are the view corridors in Berthoud when it comes to viewing to the mountains. You also have to take a look at that particular scenario, because if you're a block away from something, it's going to be this big on the horizon. So it's balancing what really is an issue. So it's taking a look at those, case by case. We did a downtown height study, and we had somebody simulate what a 3-story building would look like in downtown. You can't see it from a block away.
But to Commissioner Budis's comment, if somebody's made an application and progressed through the process over that 2-year period, and they get before us with a building that meets our regulatory standards, even though someday in the future, whether it's 6 months, a year, or a year and a half, we have to make our recommendation based on the adopted code at the time, correct?
Yeah, I think that's a good point of clarification. That's a very good point. Whatever is in place in the code at the time of application, that is the code that applies. It's not what was in the past, it's not what's in the future. And you will have those moments where, as much as you would like it, again, I think it kind of goes back to what Stan was saying, is that while you may like it a different way, it is what it is right now. And that's what we have to base our decision on. And sometimes that will occur, and I think that's just part of planning, is that you may recognize that, oh, that could be different, that could be improved, or maybe that's too restrictive. There could be that too. but it is what it is at the moment, and greatly or unfortunately. And two, I think then it's, again, it goes back to that balancing of sometimes you don't want to take it too far and make it too prescriptive, because that too can ultimately have the result that maybe you don't want. So it's always, code writing is a very unique and challenging process because you are looking at all those different dynamics.
And that domino
This-
effect, that if you change
Well-
something here,
Yeah.
then how's it gonna impact it over here?
I'm sorry, and that's I think the reason this conversation is coming up more like tonight so much is that like that's where we operate really. Like we don't like we do legislative work on the code, but really when we like act quasi judicial, it's like we're like if it's not following regulatory, like staff likely won't recommend it. Maybe I doubt it that it'll come through, but you know in that case that's an easy clear one. I think the one that like the ones that we struggle with are the ones that are like in between that, like regulatory's back here, and where we want to go is here, and it's like, does it really fit, you know? And then we have intention for the regulatory, so I think that's what the reason the question's like prominent tonight is that like that's where we operate is in between those two zones.
Well, I think the problem of not timely updating the code of things of where you want to go in the future is exacerbated in a small town because it's not like if you want to change something in Denver, it's like, oh, we need to change this, but the way the code exists today, well, we're going to approve this one, but we're going to have 100 of them in the next 5 years come before us, and those ones will be fixed. In a small town, it's like you might only have 3 of these cases ever, and by the time you fix it, like it's done, right? So that's what's challenging about small towns is there's only a handful or less of scenarios that come up, and it's like if you don't fix it fast enough, well, then it's kind of pointless because it's all in the rearview mirror by the time you do it, and you're like, so.
It's not a great way to go. And I'm not in Colorado. Can you do moratoriums? And has Berthoud ever done a temporary moratorium on something that? I'll give an example. Years ago, there was, everybody wanted first floor retail, right? And they didn't want service uses like banks, et cetera. So certain communities, while they were studying what they wanted or what percentage was okay to have in your downtown area, they would put a moratorium in place that kind of froze the code while they made so you weren't able to kind of go ahead with an application. But I don't know if that's something that you can do here or that we've ever done. Just again, because otherwise they're like, well,
buy
by
you
the
more
time we
time.
take it up,
Yep.
it's very unfair sometimes to the landowners who don't love the fact that you just put a stay on their ability to
Yeah.
do anything. But
Yep, so the time to do a moratorium is before an application has been submitted. The town trustees did have a moratorium on oil and gas development about 3-4 years ago. And they put a moratorium not because they were getting oil and gas applications. They did it because they wanted to better understand how oil and gas could or could not impact the town of Berthoud. So they did a moratorium. It lasted a couple years, and they hired outside counsel to come in and develop our oil and gas chapter that we currently have right now. And they repealed and replaced the old oil and gas regulations and adopted these new regulations. So if there is a common thread, such as oil and gas development, or it could be, whatever kind of development, the town trustees can enact a moratorium until more study can be done to determine the impact.
Natural medicine was the other one we had.
Oh, yep.
recently.
which one?
Natural medicine, so psilocybin.
Oh, yeah.
Oh yeah.
So once that legislation was adopted, we placed a moratorium while we were developing our regulations. So again, so that we could do it properly and do research. And then the
Yes, we
moratorium
did that.
came down and we adopted our regulations.
Yep, I forgot that was even more recent than oil and gas.
So then, does that provide us then the opportunity to utilize the nuance around, let's say, the definition of mixed use, right? As, in terms of how we define it, to be able to kind of wiggle around the conundrum of concern of putting something in that agrees with code, but it doesn't necessarily, like, we already kind of know that that's not what that future vision and that the code might be shifted or whatever. as long as we're consistent in terms of how we individually interpret it, since we're not given a definition. So like if I'm like, I think mixed use means 50-50, or maybe, if it's along a commercial thing, it should be 75% commercial, whatever, whatever that might be. Is that where we have the power to then deal with this conundrum of the code kind of coming in after the fact?
So I don't think we could do a moratorium on all mixed use development in the town. I also don't know if we necessarily want to have those quantifiable parameters around mixed use, because what if something absolutely wonderful came in and everybody loved it, and it was only 20% mixed use, 20% industrial, and then 80% another use? Who's to say that that couldn't work? Where if we say mixed use has to be X, then that's being too harsh and not leaving us open to evaluate something that could be really good.
And I think in this dynamic, in this scenario, what created more of that challenge is that the comprehensive plan and the language within the plan is what causes that gray. It's up to, like, my staff interpretation is that when you look at the language within that character district and it says words like primarily, or, it's those fuzzy words, is that what maybe staff would define as primarily may not be then what planning commission agrees is primarily. So I think that's where, but again, it goes back to, we don't want the comprehensive plan to be so rigid that then there is no flexibility. And while we do as planners appreciate black and white, and we like regulation, we like rules, it makes us feel safe. There's also, I think, to be able to work with your community and your developers, is that you do want some level of flexibility in some regards. Granted, yes, it's really nice to have the black and white, because it is, like I said, it's safe. And so we know we're not going to cross some line that we're then going to either regret or get in trouble. So it's hard. It's this ongoing debate of how restrictive, how specific do you want to get? And again, where's that fine line is, while we do like this, because then it makes our decision making much easier, then do we create these unknown consequences that we're then going to regret later on? So I think to that, it's like,
Yeah, that's a great point, because on one hand, we want development or we want to see change, but if we make it so prohibitive that it's not cost effective for anybody to do it, we can put all the regulations we want in the world to make the perfect development, but if it's not financially feasible, then we'll end up with nothing.
Right.
It's trying to fit a square into a round hole sometimes. I mean, I think you need that flexibility. And I think to Ann's point, if you have a developer coming in, right, and they have this great idea that no one thought about it during the comprehensive plan or any other time, and it's something new and it's something that is beneficial to the town, why would you put them in a box like that and force them to do 2080 or whatever that number is?
Yeah, and every scenario is going to be different too.
Yeah.
Is it correct? I mean, I think we've hammered our role pretty well tonight, but is it correct that when it gets to the town trustees, they don't really operate under that same premise? I mean, they're going to say, yeah, it might meet it, but I don't care. I'm voting against it because I'm using my opinion and what I think my representative, they're elected representative. I kind of joked about it last meeting, but there is some truth to it of like, whereas we're appointed, we have a very specific role, they're elected and they represent the town. So can they say, yeah, it might meet the comprehensive code, or it definitely meets comprehensive code, but I'm still voting no because I think the town doesn't want that. Is that true?
I'd like to take the birthid out of this conversation and pose the question to Sam, is should town trustees, city councils use the same parameters in voting with the criteria for approval that the planning commission uses in making a decision?
Yeah, I'd say it a slightly different way. If it's a quasi-judicial proceeding, then they're acting as quasi-judges too, and it's the same rules apply. Yeah. And I do the same training for elected officials, right? quasi judicial process, the rules of engagement apply whether you're a body that makes a recommendation or whether you're a body that makes the final decision.
yeah.
Now, within individual land use codes, you can allocate responsibilities about who does the heavy lift, how records are assembled, right, how recommendations are shared. But just to keep it simple, if the town board is holding a quasi-judicial public hearing, then the same rules apply.
Thank you.
Okay.
One more comment, because we haven't, we haven't
Wanting to
handled this
move
one.
on.
I think that like,
I'm hungry, Commissioner.
so totally agree. We don't want to. We want it to be developer friendly, right? We're going to be growing, and natural organic growth is generally the best. So like trying to put a square into a circle is just not ideal. But I think like the question is like, how do we then like interpret that? Like if we operate solely on the code, like again, we're like backwards looking. We're not ever going to be able to say like this is what the people want. And I think that that's the concern is that like if we're not like able to reference the comprehensive plan or the future land use at all in like our determination, then it really becomes like hey, we're just reading the code.
Except what is in the comprehensive plan, the vision and values has been written into the code. They did a big rewrite in 2001, 2002. We have suburban residential zoning, we have urban residential zoning, we have zoning that is in the comprehensive plan, and there were more character district type zoning. And in 2001, that particular staff did a huge overwrite of our land use code to bring the comprehensive plan into the code. And then for the end of 2024, all the way through 2025, then the three of us with our then town attorney also took a look at the residual part of the comprehensive plan and what's missing, what needs to be tightened. Over the 3.5 years that we've been here, what are things that we've seen that are confusing? And so we tightened that language up. So quite honestly, if you feel as if there's something missing in our land use code, I'd love to talk to you about it. We've really scrubbed that comp plan, and we have made sure that everything from that vision, again, that vision is from 2019 to 2021, that was a vision at one moment in time. And so that's also hard because now Berthoud's grown up a lot in those 5 to 7 years. Is this still our vision? And so that's where it gets hard for staff sometimes. Berthoud's been fantastic because we do update our comprehensive plan every 7 to 10 years. Is the vision still the vision?
And I think that's one thing I guess I'm excited about sitting here on this plan commission, and I understand it didn't get funded last year. I think we should all push to get it funded this next year, is a tweaking of the comprehensive plan or reassessing certain sections. And we'll play a critical role in that. So the things we're hearing from petitions and we're hearing from residents, that's how we'll be able to help legislatively to say, this is what we think. We're hearing it from the people appearing before us.
So again, though, if you feel as if there's something in particular from the comprehensive plan that's missing in our land use code, we'd love to hear it. And maybe it's just tucked in somewhere that we've not brought to you. And a land use case hasn't embodied that. So again.
Yeah, I'm thinking more of like the example of like we don't necessarily want to rigidly define what mixed use should be, but like if it's not in the code rigidly defined, then we kind of are like, we can't really act on it. If it's just in the comprehensive plan as gray zone, then it's like how do we lean on that without crossing the boundary of like legal concern?
So I would say for clarification, our code does define mixed use. So we do have a definition section, and this last scrub, we went through our land use table, and all land uses rightfully should now be within the definition. The thing about mixed use is what our definition doesn't state is what that percentage is, or what that quantity, or, you know, how much of it is residential. And it's not just, and I think too, it doesn't, and I don't know, I could open my code and but we don't need to go down that rabbit hole, but mixed use too is also not just one building is mixed use where it's residential and commercial. Mixed use could be that this development here could be a mix of use. So I think we looked at that as well. So, and I would say within the previous criteria, so since you're still looking at under the previous code, you're still seeing, I think, applications under the previous code. And then in our new code and our development standards, there are standards in there that do ask you, is this consistent, or is this aligned? I think it's aligned with the comprehensive plan. There's something in there that does reference the comprehensive plan. We do have standards that mention our other master plans as well. So it does ask you. So that's when your own personal experiences and your reality and your analysis and assessment, when you're looking at that project, that's then, I would say, is when, not your feelings, but that's when your evaluation and your assessment of what you think is primarily, what you think these words mean, and then that's when you all come together and determine, do we have this shared vision and understanding of what this comprehensive plan or this master plan is telling us? And so it does encourage you. It definitely encourages you.
And so there are all of these other components that go into that particular, let's call it a mixed-use development. There is traffic, there's drainage, there's stormwater management, there's utility provision, all of these things that if we had a strict, you have to be 50-50 on your mixed use. And yet that particular application was so far, the utilities that were serving that application couldn't, the utilities could not be met in an affordable way. So that's a criteria that you can use to evaluate that situation. Let's say traffic. Mixed use says it has to be 50-50. However, if it goes 50-50, then there isn't that infrastructure to support the traffic. So how do you then make something work within that boundary that can logically work? So that's where then we have to use the testimony of staff and the testimony of the applicant and the facts that they're presenting to say, yes, I want to do this mixed-use development. However, here are my factual confines, and this is why I'm proposing it a certain way. So I think the comprehensive plan provides that vision of what the intent is. However, we have to take the testimony and facts that are presented in order to evaluate, okay, can we make this vision stick, knowing what the facts are and the limitations? Is it still meeting that intent?
I think, well, what both of you said, but particularly what you said, was the answer I was looking for. And but for the record, I'm not saying we should put a number on mixed use because I don't want to box that in. But the definition should be representative of the spirit of the comprehensive plan. And I'll go back and read that definition of what it is. But thank you for that answer. That really helps me.
Yeah, I feel like that bridges the gap between what's coming and what is.
We got there.
But Karen, okay, you bring so many. Sorry to prolong this, but I'm I'm real obsessed. Okay, so to kind of debrief, right? That apartment complex, right? So
no, it's going to the board of trustees.
Oh, fantastic. Okay, never mind. Okay, never mind.
Yeah. So I don't think until they've made the decision, we should talk about it. I don't know, you might.
I appreciate that.
It's
Yeah,
a decision that was made by planning commission. The town board hasn't seen it yet. We are being recorded.
Yeah, and it's not on the agenda for a discussion. I don't think we.
Okay.
Yeah, I have kind of a fun answer at this hour on that.
Okay.
Don't talk about it because it's still pending to go to the board, and then even then, wait at least 28 days. after that.
Okay.
And even after that, it's like, through our process, we all made a record of what we thought about that issue, right? So I would definitely build a lot of time in post-decision before you want to do some debriefing on, does that experience translate to any forward-looking action steps?
We can
Because too, my example that I was used was my letter to the editor was written shortly after the decision was reached. It would, obviously it was a higher risk situation than having a couple of comments, but nonetheless, I'd wait until everything, the dust is settled.
Right, and let's let you try to get through these last slides.
Okay.
Yeah. The more legalistic reason is what if the town board decides to remand it to you,
Mhm.
right? They decide, we don't necessarily embrace the planning commission recommendation, but the developer did some things that they made changes. They're trying to sell us something different than what the planning commission looked at, so we'd like to send it back to the planning commission now.
Just out of curiosity, has that ever happened?
Not in Berthoud.
Oh.
In the 3.5 years that I've been here.
Yeah.
No. So this is our zoning map. This is legislative. So taking a look at that little green ag property that's just south of Newell Lake, if somebody wanted to come in and say, I would like to build a smelting plant there and do some candle making and, high intensity industrial uses there, it's currently zoned ag. Could they come in with a rezoning application? Of course. We have a process. If you want to rezone something, as long as you're following the process, of course we could support an application. Will that be approved? We don't know.
What does T stand for?
T, transitional. It's a zone district that we no longer recognize. And what T transitional stood for is a long time ago, we used to annex properties without concurrent zoning. So you could continue your current uses on that property and not change as long when you were zoned T transitional. We have some transitional zoned properties that are 20, 30 years old now, and they've not zoned to something. And we've had little, I'm just going to add one more thing, or I'm just going to add one more thing, and it's now blossomed into something not good. So we're going to anything that's zone T transitional in 2027 that the town owns, we are going to be actively rezoning everything, and that will clean up the majority of the T transitional. There are still some, and just through time that will clean those up.
Thank you.
Okay, so you all should know this slide by heart, because every land use presentation we open with this. And Ton and Bella, they live in this. So we have the pre-application meeting phase. And honestly, sometimes somebody will present a application and then they change their mind 3 months later and they want to come back and have a pre-application. Ton organizes what's called pre-application prep. Do you want to explain what that is?
Yes, so it's the very first staff step, if you will. So before any pre-application meeting that we have scheduled, I schedule and perform a prep session with internal staff who are on our primary referral agency list, and as well as Berthoud Fire. So that is planning department, our town engineer, representatives from our public works department, water utilities, and then of course our town administrator, economic sustainability manager is also there. I'm trying to think. So it's just an opportunity then for us to prepare as staff to see this concept that's before us at the pre-app, so that we can come together, get all on the same page, know exactly where this is, what we're looking at. So they'll go back to their respective offices and then they'll do their research on this property to figure out their component of the conversation. So that then when we go into the actual pre-application meeting with the owner or the potential applicant, that's when we talk to them about their concept on a very preliminary level. to really give them an idea if it is viable for them to move forward. So it's an opportunity to get all and every question they have answered about where's the closest, where's water utilities, how far do I have to extend? Fire can tell them you don't have fire hydrants within a certain distance, so do you expect to have to develop these 3 fire hydrants? So it's that very high level conversation so that they can really think, is there just so much that we're gonna have to do that we can't do this, we can't make it pencil, so we go away and come up with something else, or just abandon the idea altogether. So that prep is very essential for staff so that we're a unified front, and we're really good about communicating as a whole in general. But we also want to be cognizant of our applicants' time and their money, and being that time is money. And plus it just sets us all of us, applicant-like, for success moving forward.
Yep, oftentimes applicants, there won't be sanitary sewer, or it will be cost prohibitive to bring sewer to that development, and in Berthoud, development pays its way. So if somebody had to bring a 24-inch sanitary sewer line to serve the development for 3 miles, depending on the density or the type of development, that's probably not going to work. So we want to be kind to the developers and all of us be on the same page as well. And then sometimes people want to have just a general scoping meeting, and that will be, well, do you think something like this could even fly in Berthoud? So before somebody would enter into a due diligence contract on a piece of property, they just want to know, could you get on board with this concept? And we'll even do those scoping meetings before a formal pre-application meeting. So there's a lot of time that's expended by Ton and Bella and the other staff, just having people talk about the concepts. There are minutes that are provided, lots of after questions. And this is on top of juggling, staff's work, the caseload, and then the special projects too. However, our goal is to give everybody the best information going forward, our design guidelines, landscape guidelines, our development expectations, so that when we get that first application in the door, we're not doing design by development review, which what was happening when we first came here. Now we're actually asking the applicant, tell us how your application meets our codes and our standards. So we're not 100% there. We're still working on it. And however, we are getting there. Then we have the application submittal. Staff has, 7 to 10 days to check an application in. Do they have everything that's required? Did we tell them that they had to do a full traffic impact study with the application? And here they've just given me a 1-page memo. During the pre-application phase, we suggested that there is a drainage problem in this area. What do we got here? So we do high-level review during that pre-application phase. And application submittal, it's called the completeness review. And then once it's checked in and complete, then
it's scheduled for referral agency review. So pretty much everybody who's in the room in our pre-app is then also on that review list, plus a whole ton more. So that's then when we pull in like Xcel Energy and Lumen and Poudre Valley REA and the school district. So it's a big old list. And so we have a standard template that Bella and I both follow, that we provide then a request that they do this review within this time frame, which is a 4-week review. And then it's kind of out there with everybody, and we sit back and do other things, and then after that 4 weeks, we close out that review period, and in that time frame, we're getting comments just randomly wherever, whenever people can get them done, they send them on to us. We collect them, compile them, save them into our historic document folders, and then at the end of that 4-week, we follow up with any referral agency who hasn't responded to make sure that they're aware that it's closed and we're waiting. And sometimes they just don't respond. And then we review everything, do any follow-up. So if we have questions on referral comment, we will do that initial work to follow up to get clarification so that then we can clarify those comments for our applicants. And then we provide what's called a staff review letter. So then we complete our review from a planning perspective. So that's when we look at the development code, the comprehensive plans. We look at our pre-application minutes to make sure that we didn't miss anything. So we go back through all those different steps to make sure that we're covering all of our bases. And that's then, and our staff review letters can be anywhere from 3 to, I've had it to 13-page document of nothing but comments about how they're missing the mark on the code. So it's can be simple things where your spacing amongst your street trees is incorrect. We have standards within the code that define that. Or your tree strip isn't wide enough, to more complex things of how they are labeling easements or they're missing easements. And then we look at design components of, things that we just know over time and having background in design, looking at, snow storage in some cases and how it is that they have alleys and where you're going to put the snow and making recommendations. So there's a whole lot that we look at, and we provide all those comments in a staff review letter. And then we send it within that, we have a 2-week time frame to get that completed, and we send that to the applicant, and then it's back in their hands to then address every single one of our comments, along with all the different referral agency comments. And so it's quite substantial. I think oftentimes our folders of comments can be anywhere from, I would say at a minimum 6 documents all the way up to 20 some documents that they're reading and that they're processing. So it will take them on average, I would say about a month to make those on average, often sometimes much longer. They make all those revisions, they take whatever time they need, and then they resubmit, and we go back through that process all over again. And so until we get comments back saying all prior comments have been addressed, no further comment, then that's when we start to bundle it up and get us closer to public hearing. And then once we finally get that, yep, everybody's given us the thumbs up, we go ahead and schedule.
And in Berthoud, we do not bring anything to you with conditions. Everything is supposed to be clean and ready to roll. And the reason why we do that is if we bring 10 conditions to you, oftentimes that's setting an applicant up for failure because they can't meet those conditions. And then we're left with plans rolled up in our office that, hey, this was approved by Planning Commission and Town Board of Trustees 2 years ago. They're still trying to work out these conditions of approval. That's not good.
So let me ask a question, because you mentioned referral agencies, right? They have 6 or 4 week windows, basically. What happens if they don't respond? You send them a note, they still don't respond. Do we move forward? Because I think we've had this before where something came to Planning Commission and then all of a sudden one of the schools had an issue.
Yeah, so this is the fun part.
Yeah.
We can only hold people, accountable. We only have so much power. And ideally, and this is not just unique to Bertha, this is common planning policy, is that the rule of thumb, and all referral agencies know this, that if you don't reply, you don't respond, that is our assumption you are responding in the affirmative, meaning you have no issue with what you're seeing, and so we will move on without you. And that means the next submittals that come in, you don't get to see. So that is something we don't desire. So that's why we make it a policy that if you don't respond, or if I don't see your comments in my emails by the end of that 4 week, or I'll give them typically another additional 4 days or something along those lines, I'll follow up and say, hey, and I'm wrapping up my review and realized you didn't provide comments. Please let me know if you intend to do so, or if you need an extension. Because referral agencies are more than welcome at any point in time to request an extension. And generally, we like to keep it to no more than an additional week, just out of consideration of applicants' time. But we also don't want to shut the door on them if we don't have to. There are referral agencies, I would say, that you start to develop a pattern. So like Poudre Valley REA, for instance, in Excel, they share we have their maps and we know what their general service areas look like, but oftentimes they don't provide comments. And I would say generally it's not concerning to us if they don't provide comments. Whereas fire district, every single time we have a referral, whether they provide comments the first time around or not, we provide them a new referral. Because it's just, or CDOT is another one. If they haven't provided comments, we are very diligent about always following up, or just no matter what kind of submittal we get, they get a referral. Because it's just very important to us that they just are kept in the loop. School district, the same thing. Sometimes we'll go periods where they're really adamant about providing us comments and really great, and then we go periods where we don't hear anything. And currently, we're in one of those periods. So, and it's a bummer, and it's frustrating for staff as well as obviously the applicant, like in that
Right.
one particular case, because it's like you've been provided ample opportunity,
Right.
and you didn't provide us comment, and this is frustrating, and this is why we do it this way, because it inevitably will hold up the project. Yeah. So it really does come down to some we just know won't, and that's cool, that's fine. We just also want to give people the heads up. So, and the counties are the other one. Counties like Larimer County and Weld County, we give them always a referral as well because we are so small. General rule of thumb, because of our intergovernmental agreements, is that they offer us a referral when the project is within 3 miles of our GMA. And then so we share that same courtesy. Anywhere in Berthoud is going to be within 3 miles of Weld or Larimer County. So we give them referrals, and whether they respond or not, that's okay. We just want them to know that it's there. Yeah. Good question.
Well,
If I could ask you to try to work on wrapping up, though. We're north of 3 hours, and I want to make sure that we get through.
Yep, so then we have the meeting and post-approval actions. You're familiar with that. Then again, this is the desired process. We have pre-application. It can last anywhere from 2 to 6 months, depending on the nature of the application. The application submittal and development review can last 4 to 8 months. Again, depending on how substantive the referral comments are, how they need to address things. Sometimes the developer and their applicants are really speedy and they're very anxious to get things going. Others just languish, and that's personal choice. Then we have the public meeting and the hearing. Takes about a month, maybe 2 months. And then post-approval actions. The reason why we want things squeaky clean without any conditions of approval is because we require the plats and the Mylars to be recorded within 30 days of the final decision. So if we have conditions of approval, we can't oftentimes get those conditions met within that period of time.
We keep,
So-
quick question. Do we keep metrics as far as like how many applications? Like it sounds like we have a really good process and we try to do a lot of due diligence on the front end. Do we keep metrics like on how many applications get submitted and ultimately get approved versus disapproved as a way to go back and reflect on like, is our process working well? Is it efficient? Is it effective? Is our code clear enough, or do they keep having consistent problems explaining how they meet the definition, and like maybe that's a red flag there? So just,
Yep.
you don't have to
Yep. And
too long of an answer, but
we reevaluate. So we keep a yearly list of all of our pre-apps that we complete, and or scoping meetings. We keep track of all of them. We do keep track, and we do keep count of every single active application that we have every single month. We do keep track of all those numbers. Yeah, and we do. We pay attention. We reevaluate. Especially at the end of the year, is how are we seeing changes in reviews and how long that response time is taking. So we need to take a look at that. And we have been really diligent. Like we just recently kind of revamped our pre-application process to try to restructure it in a way that maybe we would start to see better submittals initially because we weren't. And so then we were seeing just really long review times because we weren't getting quality in at the beginning. So I think we're starting to see kind of an uptick, and we work diligently with applicants. Like our project narratives are by far one of the things that have come very far since we've started, and so it's just constantly working on it. So yes, we do keep track
is that
of all that.
like once a year do you present that to the commission? Just to
I don't
show.
believe we do. No, we talk about it more internally, just about what
Yeah.
changes we think are necessary.
That's good.
And
It's important because the reality is we're competing with other smaller towns around. So if our process is cumbersome or not effective, then we may lose out to certain.
So
Exactly.
last year we met with the development community and the business community, and we asked them what about our process could be improved, and we took that information and we poured it into our code. One of the things that we're going to go through the anatomy of a staff report, and we're almost done. So this is where we like it when you are reading that staff report and there are hints that we're giving you about how long something has taken. So if you can imagine that staff report, that very first page that tells you what the zoning is, what the request is, where it's located. There's a great aerial map in there. It's giving you all of that. What am I looking at? What is it? Where is it? What are they asking for? And what's around it? On that very next page, you're going to see background history. Application was submitted in 1889. Staff reviewed it in 6 weeks. It sat for 20 years. Application was submitted in 19 whatever that is. The applicant reviewed it in 6 weeks. I'm over exaggerating because it's late.
This is a real quick case. I want to know what it is.
Yeah. They sat on it they sat on it for another 6 months. Staff reviewed it in 6 weeks. Applicants sat on it. We're at the 22nd submittal. It's now spanned several staff. We're now here to get to a public hearing. Okay, and that could be a question that you call staff. I notice that they've been in the development review process a long time. Has something changed? Maybe they changed the composition of their project. They went from all commercial to residential to what? What did they change during this process? You can ask us, we'll talk to you about process, and then you could also come to the hearing and you can say, I notice you've been in a long time, and I asked staff, and I understand you went from X to Y. Can you explain why you did that? Can you explain how this is better for the town of Berthoud? You can ask those questions. However, sometimes staff is just saying, oh my gosh, well, can they please just read the staff report and answer the questions? And on their 15th submittal, can they please just submit what we're asking for the 10 times prior? So sometimes we just really want you to read that and see the amount of energy that has gone into staff holding people and getting them to that finish line, because there might be something there that we really want you to know about and we just can't say it. So, all right, then we're going to give you the process, the project history. They're wanting to do X, Y, and Z. It's more of a narrative. It's telling you the type of development, how many types of housing units it's going into, and they want to, they're meeting the housing diversity code this way, and they're meeting the neighborhood identity features this way. It's giving a lot of good history there. And then those wonderful tables on the criteria for approval. And based on everything leading up to there, it's like a story. Everything leading up to the end, right? That end. Here's the criteria for approval during this entire development review process, why staff believes something does or doesn't meet that criteria for approval. And it gives you that code, and then we will give you the worksheets and you can work on that during testimony. So then we're going to also tell you public notice requirements. Was the site posted? What did surrounding property owner notice postcards go out? Did we publish it in the newspaper? This is also a checks and balances for us, so we don't say, oh, whoops, I forgot to do something. And sometimes that happens, and it's okay. Then findings and recommendations, again, that code citation and rationale, and then the list of attachments. There might be 20 different correspondence from surrounding property owners, or there could be the traffic impact study. We're usually not going to give you the Alta title commitment. That our surveyor's going to take a look at that. Okay, so if you have questions about the staff report, please call us, because we put a lot of energy into that staff report. Bella and Ton, more than you get stuck with me sometimes doing them. Just there's a lot of blood, sweat, and tears that goes into that staff report. And we also review each other's work. When I'm writing a staff report, I'm asking Ton and Bella, I'm trying to make this point, I'm trying to say this. Am I communicating it clearly? I need help. I'm struggling with something. We're just not making these independent decisions. We're working together, and we loop Luke Sieber in, the development review engineer, a lot of times. So we're collaborating a lot, because we want to make sure that how we're interpreting something makes sense to us as town planners, or we don't know how to say something in a succinct way that makes sense. So we're always looking for those opportunities.
And I guess I'd like to encourage people, to the extent possible, to ask those questions here at the meeting. Because chances are, if you have a question on it, somebody else does as well. And it's important for us to all to kind of hear the answer the same way from staff. So.
Okay, then we all see this slide. And that was exactly what the point is: question to seek facts, to clarify. Ask lots of questions. Sometimes the most frustrating thing for staff is when we have to sit there and we're thinking, gosh, I really want to say something. I think it may add value. However, I don't really know. Are you open? What do you want? And Chair, you have been very gracious, and you say that you want us to jump in and say things. And we want you to ask us questions too. Okay, so meeting prep. Review your packet. If you are having an odd week and you can't review everything, read the staff report. That's going to give you a lot of information. We talked about this. Should you contact other planning commission members? The answer should be no. Should you contact the town board members? Should you contact staff, and if so, about what? We've talked about that. Do you view old videos for former steps, such as, and this, I'd like Sam's input on this, and we can ask our town attorneys about this too. If we're looking at the preliminary plat, should we go back and look at the annexation and zoning videos? What do you think?
I'm not sure about that, because if you're preparing for a specific hearing, I guess I would encourage that your staff report have enough background to understand where you've gotten to, right? And that should do it, would be my deal, right?
And then should you poll others? Should you talk to your friends? Should you talk to your spouse? What do you think about this? I have this coming up. What do you think? So no. Okay. All right, we've talked about these. Conflict of interest, even an appearance of a conflict of interest. Coming in neutral, being unbiased. What does making a motion do? Oh, making a motion in the affirmative. I think we'll talk to our town attorney about that one. Should motions be made for denial, or should the affirmative fail? Those we'll talk to the town attorney about. What should be done by the commissioner who is the only one that voted a certain way? We've talked about that. What did you say?
Chastise.
Yeah. Chastise the other.
We have a chapter in our elected officials handbook called the Outlier Syndrome, which talks about dynamics around that issue. But it's more about legislative bodies than quasi-judicial bodies.
So with that, that does conclude staff's presentation. And if you have any follow-up questions of Ton or Bella or Sam, please ask them now because I need to go into the hallway for a really quick second. Sorry. And then we'll come back and wrap up.
Anybody got any more questions?
Ask anything.
Again, like I said before, I think these conversations are always good. Kind of puts us back on the rails and makes us think twice about, how we participate in some of our decisions, and stuff like that. So I think these are great meetings.
Well, and I think by the fact that we took as long as we did, we obviously had a lot of questions and needed some input from you on a number of different areas. So thank you, Sam, for being here. Thank you, staff, for all you did to get the presentations ready. It's a continued discussion, right? That's will evolve. The next step, though, is staff report. Any items from the town board hearings, upcoming opportunities for plan commission, and what do our meeting schedule look like moving forward? Do we need to wait for Ann?
I can start.
Okay, great.
The in-person historic walking tour run by the Historic Preservation Advisory Committee is this Saturday at 11. So if you'd like to join us, we'll be meeting in front of the museum at 224 Mountain Avenue, and it'll be about an hour. We'll be talking about some of the local historic landmarks in downtown Berthoud and giving you some fun facts and enjoying what hopefully is a nice day out. So feel free to join us. And we've been doing a lot of work in HPAC, Historic Preservation Advisory Committee, on work planning for what the next couple years are going to look like now that we have our Historic Preservation Master Plan. So there'll be some continued action there, and that's a very exciting piece of momentum for that committee. Do you want to do public art?
Yeah, I don't have much on public art. We did meet with them today, our consultants, that is, about our master plan. So we did see the very early beginning stages of the master plan itself, so that's pretty cool. They are also working with us. So the fun part is the master plan is only one component, and we do have budget remaining that is going to go into the development of, ideally, 3 additional art pieces by the end of the year here in Berthoud. It's a big goal. It's a really big goal, but I'm hopeful that we'll at least have a couple of them in process, and with maybe the third one that is working on if we don't have them complete. So they are kind of helping us come up with some ideas on that initially. So that was fun today to be able to actually look at some art and potential. So you'll likely see that. To move forward, it will be in the master plan. But that's where we are. And ideally, the master plan will be going to hearing in August, so it's really not that far away. So we'll now start really ramping it up and meeting with them probably on a weekly basis rather than, or bi-weekly. So,
And did you start the art commissioner committee?
no, not yet. So we did. So that's probably this initial draft. Is kind of listing out the members that they're suggesting should be present. So we have quite an extensive list of individuals who have said that they are interested. I think it's like some 35 individuals. So it will be like any other process. You'll have to go through an application and then through all that. But it's awesome that we're getting so much interest, and it'll be a fun committee, I'm sure, to be on.
And then I don't know if while I was out, thank you, if you talked about the landscape guidelines that went to the last hearing.
We just did
or
HVAC.
okay.
Yeah. So as you know, you guys heard the landscape design guidelines amendment that did go to the first hearing or introduction to the town board of trustees. That was this week. Was that this week? That was this week.
I think I saw them in the video.
It's like just 2 days ago. So it's an introduction, so they don't make any kind of vote on it. So it is scheduled to go back in 2 weeks, but I think there's something unique about that hearing, potentially. So they didn't have any questions or comments on it, so I suspect it will be adopted next hearing. So it's moving along.
Oh, and the Berthoud Industrial or Buckner request for annexation and zoning that you all heard on May 14th, was heard by the Town Board of Trustees on Tuesday as well, and they took your recommendation of approval and approved those 2 requests.
And right now, we don't have a land use hearing scheduled for the 25th of June, so we might have a non-planning commission night that night. If the town attorney is able to come and we can ask some of these questions, we definitely will ask them to come just for that session.
Very good.
I may not be able to, I have a mom that's gonna have heart surgery that week, and I don't have a date.
Just keep us posted.
Thank you.
Yep, it will be important to have as many people at that session as possible. So if we have folks that can't come, I might postpone it and just not have a meeting that night so that we can all be part of that.
I would say don't count on me, because we have to get to that week. She's got to get pre-op stuff. They won't do the pre-op stuff until, right, she's scheduled for surgery that day, but they could move up or back depending on what happens in the next week and a half. So.
Thank you. So we will probably have a bye week, and you can have, and then the next meeting would be on July 9th. Yep.
Question for staff. A few weeks ago at the town trustee meeting, they approved funding for
So when,
Berthoud to collaborate and become an official Main Street. I think I'm using the right term. Has there been any conversations, or will be there any conversations of how that intersects with our mountain overlay? Because I think there's a lot of overlap there. Is that you guys are on your radar?
Yep, so the town trustees did not approve funding, they approved.
Oh, I'm sorry. Yeah,
That's okay, the
that's correct.
town to
Yeah.
work on,
They wanted
on
a
a
MOU or
contract?
something. Yeah.
yeah.
Sorry.
And that's okay, and staff has been working on a contract, our town administrator is leading that charge. And then the current Main Street chairperson did come in
Right.
and have a meeting to talk about what their district boundaries are. So, and I've had conversations with the state as well on that, so that we're all aligned. And I'm assuming in the next few meetings, the town administrator will bring forth a draft contract or a memorandum of understanding. And I just don't know where that is when Chris getting that to the Main Street organization. They have to take a look at it as well.
Okay.
So, yep, but it is moving forward, and yes, they do know about our comprehensive plan, they know about our sign code, they know about the Mountain Avenue overlay, and the Main Street organization cannot overrule or overrun the code. They will need to work within that confine, and so we want them to be successful, because even though they start very small, it can spread to other parts of the community and have that success and that engagement. And so we want them to have success. And so we want to be supportive and work with them.
Great. Thank you. I was curious about that engagement.
Any other questions, All right,
Can
with
you turn
that,
his
can I
mic
have may I have a motion to adjourn?
I move to adjourn.
A second.
Second.
All in favor?
Aye.
Anybody want to stay and keep talking? Motion, meeting's adjourned. Thank you, everyone.